Your Honor, members of the jury, opposing counsel, my name is Sadie Forkner, and today I will be portraying Avery Becker.
Good morning, Your Honor, opposing counsel, ladies and gentlemen of the jury. My name is Dylan Schneider, and I will be portraying Taylor Perkins.
Good morning, Your Honor, opposing counsel, members of the jury. My name is Evan Grabdahl, and I will be portraying Professor Blake Van Owen.
All right. Thank you, folks. I appreciate that. Next, we're going to swear everybody in, and then we will wait for our all clear order from everybody. In the interim, what we'll do, so I'll do the swearing in, and then as we wait, everybody, you're welcome to disable your cameras in the meantime. And then when we get started, I'm going to have the attorneys for the defense and the attorneys for the prosecution, at least as far as your relevant participation in any given segment of the trial, you'll keep your cameras on during that time, and then just the one witness as we move through. Let's get started with team members, if we could, please. So for the team members, if you'd all raise your right hands, I will swear you in. All right, team members, do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Thank you. Thank you, folks. Witnesses, if you would please raise your right hand to the extent you had not just done so. Witnesses, do you promise that the testimony you are about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition?
I do.
I do. Yes, Your Honor.
I don't see anybody in the gallery on camera, but if you are over there, you can raise your right hands. I don't need you to flip it on. And I will trust that you'll work with me along through your swearing in. So for the gallery members, including teachers and attorney coaches, family members, and friends, your right hand should be raised right now. And by doing so, you are promising to represent yourselves first and foremost as positive role models and to behave in a manner that exemplifies ethical and professional sportsmanship during and after this mock trial round. Last folks that we need to swear in then are going to be our scoring panelists. If you would please raise your right hands. And for our scoring panelists, do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition? Okay. Excellent, folks. So I think for now, we're just going to hang out and wait for our all clear order. And then once we get that, we can go ahead and we will jump right in. As I mentioned, you're welcome to turn your cameras off for the time being. And when that comes through, we'll hop back on and get started. Thank you.
Sorry, I missed that. If you're waiting on me to give you the okay to start, we're good to start. All the other volunteers in the other rooms are good.
Okay, excellent. Thank you very much. All right, folks, we're going to go ahead and get started here then. So I believe we will begin with opening statements unless there are any housekeeping matters that we need to go through for the people.
Yes, Your Honor. The defense would like to request permission to constructively publish exhibits by assuming that members of the jury and yourself have access to copies, and then after the exhibit has been admitted, screen sharing them.
Give me one moment there, Mr. Littlewood. Ms. Sayers, any objection to that as a preliminary housekeeping matter for you?
Your Honor, it was the people's position that when entering an exhibit, we would ask the witness and counsel to refer to their case material, and if it is admitted, it would then be screen shared to the jury.
And Mr. Littlewood, I think that's probably the best way to do it so we don't adulterate any witness testimony to the jury. So we'll conform with that. As you introduce exhibits, if you're going to be referencing them, you're welcome to share them, but we won't consider them constructively published. And what we'll do is we're going to proceed first with housekeeping matters from the people, and then I will turn to you, Mr. Littlewood, after we've heard from Ms. Sayers. So Ms. Sayers, any additional housekeeping matters we need to address from the people's perspective?
Yes, Your Honor, the people have 3 additional preliminary matters. For our first preliminary matter, the people request that the stipulated facts be constructively read into the record.
Mr. Littlewood, any objection to stipulating facts being constructively read into the record?
No objection, Your Honor.
All right, those are constructively read into the record, counsel. What's next?
For our second preliminary matter, the people request that the jury instructions be constructively read into the record prior to closing arguments.
Mr. Littlewood, any objection to the constructive reading of jury instructions after the conclusion of closing arguments?
No objection, Your Honor.
Those will be constructively read. Ms. Sayers, what's the third item we have to take care of today?
Finally, Your Honor, the people request that any remaining time on Mr. Powell's closing argument be reserved for rebuttal.
I have no problem with that. Counsel, we will reserve that time as you have requested. Mr. Littlewood, other than the matter we addressed earlier, sir, what else do we have from the defense for housekeeping matters, if anything?
No further matters, Your Honor.
All right, excellent. Ms. Sayers, then, are you ready to proceed? And I'll ask Mr. Littlewood the same.
Yes, Your Honor, the people are ready to proceed.
And Mr. Littlewood for the defense?
Yes, Your Honor, we're ready to proceed.
Excellent. All right, folks, let's go ahead and get started with opening statements then. If we could, please, Ms. Sayers, the floor is yours. Ms. Proctor, the floor is yours.
Yes, Your Honor. Towers, texts, and tantrums. Mackenzie Brackman was an attorney. Running around all day was just part of the gig. He also volunteered his time at the local high school as a mock trial coach. So for him, moments of rest were few and far between. On March 6, 2020, though, he finally got one of those moments. No more worrying about his upcoming case or reports of the coronavirus coming to the United States. No, today was his day to focus on himself. Ding, motion at your front door. Ding, motion at the side gate. And as the back door slides open, one more alert. It all happened so quickly, and Coach Brackman reached for a weapon to defend himself. One moment, he was relaxing, and the next, he was fighting for his life. But before he knew it, there was a knife in his back, and he was bleeding out on the floor. The masked and hooded intruder fleeing the scene. Turns out his attacker was Avery Becker. Your Honor, counsel, members of the jury, my name is Madeline Proctor, and together with Feliciana Sayers and Chalmers Powell, we represent the people of the state of Colorado. Now, we have the burden in today's case to prove beyond a reasonable doubt that the defendant, Miss Avery Becker, committed the crimes of second-degree burglary, which is criminal mischief, and by extension, first-degree murder. We will meet that burden. For now, focus on three things: towers, texts, and tantrums. Towers. Detective Markowitz used cell tower data to find out where Avery Becker was on March 6th. These records proved that she was in the same cell tower arc as the victim's phone. Her phone pinged not just once, not twice, but 3 times in that very same cell tower arc. Texts. Alex Cifuentes received text messages from the defendant's phone threatening to vandalize Coach Brackman's house. These messages were sent the day before the murder, and they paint a portrait of the defendant's motive to go to Coach Brackman's house on March 6th, break in, and vandalize it. Tantrums. Miss Becker went to Coach Brackman's house on March 6th to vandalize it. A burglary gone wrong. You see, Miss Becker had won some awards at the regional mock trial tournament, but Coach Brackman told her she did not deserve those awards. So what did she do? Miss Becker got mad, and she took a Sharpie to Coach Brackman's car. When he saw this and kicked her off the team for good, she got even madder. This gave her all the motive in the world to go to Coach Brackman's house on March 6th, break in, and vandalize it. The defense has no obligation to present evidence in today's case, but we expect that they will. Their purported expert only investigates other people's work. He does not do any investigation of his own. Taylor Perkins is loyal to the defendant. He will do anything to help his best friend. And the defendant has every possible reason not to tell the truth. Members of the jury, the case in front of you today is a tragedy. Coach Brackman dedicated his life to shaping the youth of America. He was a shining star in the community, but that light extinguished when he bled out on his floor on March 6th. Towers, texts, and tantrums. At the end of today's trial, Mr. Powell will stand before you and walk with you through the evidence. He will ask for a verdict of guilty. Thank you.
I'm on mute. Thank you, counsel. Opening statements for the defense, if we could, please.
Yes, Your Honor. Ladies and gentlemen of the jury, we are complex people with complex problems, and complex problems don't have simple answers. The case the prosecution will present for you today is an attempt to answer a complex problem, Mackenzie Brackman's tragic and untimely death, with a simple answer. Avery Becker didn't like Mr. Brackman and therefore must have killed him. Simple, right? But what you will see when you look below the surface of the prosecution's case is that their simple answer doesn't make sense. It doesn't make sense because Avery Becker did not kill Mackenzie Brackman. The defense will present the defendant, Avery Becker, and her alibi, an alibi that was never investigated into by the police on the prosecution's side, despite their knowledge of one. Today, instead of speculation on part of the police, Avery will get up on the stand and tell you herself where she was when Mr. Brackman died. She was at the mall with her friend, Taylor Perkins, looking for her missing phone. But you don't have to just take Avery's word for it. Taylor Perkins will also tell you that she and Avery were at the mall looking for Avery's phone on the day of Mr. Brackman's murder, March 6th, and had no intention of ever going near Mr. Brackman's home, especially since they didn't even know his address. Ms. Becker will also illuminate the nature of the relationship between herself and the late Mr. Brackman, how it was one of expected high school frustration, but certainly not murder. Not only this, but Ms. Becker will also testify to her relationship with Alex Cifuentes, showing that they were hardly close confidants, certainly not close enough to exchange the string of text messages received by Detective Markowitz. Most importantly, though, ladies and gentlemen, Ms. Becker will explain how her short-lived, rash behavior after the regional tournament did not push her further into violent behavior, but rather to immediately see the error in her own ways and abandon such behavior. It didn't push her to plan to break into Mr. Brackman's house, but as she will explain, motivated her to make amends for her past behavior and apologize. The defense will also present Blake Van Owen's investigation into the murder of Mr. Brackman, which takes into account the pieces of evidence the prosecution has ignored. Mr. Van Owen, an experienced private investigator, will explain what exactly happened on March 6th using detailed analysis on both evidence gathered by the police and evidence the police failed to gather, including the phone records of Taylor Perkins, which show Perkins in the vicinity of the mall at the time of Brackman's murder, lining up with both Perkins and Becker's alibi. There is no doubt that this case is a complex one and should be treated as such. However, the prosecution has ignored important pieces of evidence and reduced the complexity of the case to a simple answer. As you will see, the clean line of events Detective Markowitz and Kyle Kuzak have constructed from the evidence they found at Mr. Brackman's home does exactly this. Today, the defense will show you that Detective Markowitz initially thought a former client could have killed Mr. Brackman, but failed to investigate any of those former clients, their whereabouts at the time of the murder, or even their names. The detective also failed to interview 7 out of the 9 members of the mock trial team, as well as failed to investigate the phone records of Alex Cifuentes. In short, the detective failed to investigate any theory that may have contradicted his own simple answer. Similarly, the defense will show that Kyle Kuzak failed to consider that the knife used to murder Mr. Brackman and the knives Mr. Brackman had in his kitchen block were of completely different brands. He also failed to investigate the Ring doorbell records of Mr. Brackman, records which were vital to the line of events displayed in their theory of the case. Not only this, ladies and gentlemen, but the defense will present to you both Mr. Kuzak and Detective Markowitz's striking negligence in investigating any suspects besides the defendant, Avery Becker. Mackenzie Brackman also had a life of his own as a criminal defense attorney, though Kyle Kuzak and Detective Markowitz have narrowed a complex life into the confines of a single high school mock trial team. Ladies and gentlemen, today the prosecution must convince you beyond a reasonable doubt that Avery Becker is guilty. However, the evidence they have built their case on only reveals a simple answer to a complex problem. The defense will make clear that there are pieces of evidence and alternative theories to the case that point in a direction other than this simple linear story. That true justice was ignored in favor of a simple, clean answer. We implore you to cast not guilty. Thank you.
Thank you, counsel. For the people, are we prepared to call our first witness?
Yes, Your Honor. The people call Detective Jordan Markowitz to the stand.
All right, thank you. And Detective Markowitz, if you would, please, I'm going to ask you to raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you are about to give today is the truth, the full truth, and nothing but the truth?
I do, Your Honor.
Thank you. The witness has been sworn. Counsel, you may proceed with direct examination.
Good morning, Detective. Please introduce yourself to the jury, spelling your last name for the record.
Good morning. My name's Jordan Markowitz. That's Markowitz.
Detective, let's talk about your professional career. What do you do for a living?
Currently, I'm a homicide detective for the Denver Police Department.
How long have you been on the force?
I've been on the force for 13 years, and I've been a detective exclusively for the past 7.
Over those 7 years, what skills have you acquired?
I have grown and developed many skills in the field, especially skills concerning cell phones and forensic data recovery.
What does that mean?
This means I have the ability to acquire and decipher cell phone data, records, and cell tower data, and the skill to use forensic software, such as the Celebrite system.
Tell us about your specialized training.
Beyond attending the Basic Police Academy, I also attended the American Academy of Law Enforcement.
What did you do at the American Academy of Law Enforcement?
While in attendance, I took a certification class over cell phone technology and forensic data recovery.
How long have you, or how many times have you used your training and that certification?
I have downloaded and interpreted the contents of hundreds of phones. In addition to that, I have obtained and analyzed cell tower records in over 50 cases.
Your Honor, the people request the court to recognize Detective Markowitz as an expert in the fields of cell tower analysis, crime scene investigation, and forensic data recovery. Pursuant to Rule 702, his skill, knowledge, education, experience, and training have been shown, and his testimony will assist the jury in understanding the evidence.
What's the defense's position on the tender?
Your Honor, the defense does object to this witness being expert witness and would like to conduct a brief voir dire.
Briefly, counsel, you may.
Thank you, Your Honor. Good morning, Detective. You did a 3-day training. You did a 3-day training in cell phone data recovery and forensic data recovery?
Yes, ma'am, a comprehensive 3-day training course.
But you don't have any other training in cell phone data recovery or forensic data recovery?
No, ma'am. I only took the class at the American Academy of Law Enforcement.
You don't have a degree in forensic data recovery?
I did not include my degree in my statement.
You don't have a degree in cellular electronics, though, as you put in your statement.
Ma'am, I did not receive my specialized training until I became a detective. Then I received specialized training so I could better investigate crime scenes.
But you never had an update on this certification course that you took?
No, ma'am, I did not.
Your Honor, forensic data recovery is a highly technical area of expertise, and based on the fact that Detective Markowitz obtained his certification from a 3-day course alone, the defense would like to object not to crime scene investigation, but to a certification as an expert in forensic data recovery and cell phone data recovery.
Briefly, what's the prosecution's position?
Your Honor, pursuant to Rule 702, Detective Markowitz has testified that he has skill, knowledge, education, experience, or training in those in cell tower analysis and forensic data recovery, and only education or training is required to tender Detective Markowitz as an expert in those fields. That goes to what Ms. Damia Damiana said on her voir dire goes to the weight of Detective Markowitz's testimony, not his admissibility as an expert.
I'm inclined to agree with that, counsel. I think your argument for the defense side does go primarily to weight as opposed to admissibility. That sounds like ripe area for cross as well as foreclosed for your jury to explain or elaborate on the very limited set of qualifications. That being said, I do think it meets the standard under 702, so I will qualify the witness as the tender was requested. You may proceed at this time with your examination, counsel.
Yes, Your Honor. Detective Markowitz, have you formed an expert opinion in today's case?
Yes, sir, I have.
How do you form your opinion?
It's my job as a detective to take simple pieces of evidence and piece them together to form the most rational conclusion. And as it is my job to collect and interpret evidence, it's crucial that I remove myself and any personal bias that I may have. It's my job to follow the evidence and go where it takes me.
Let's start at the beginning, March 6th. What happened that day?
I was dispatched to 444 South Flower Street near Broomfield, Colorado. I arrived at approximately 1400 hours.
Upon arriving at the scene, what did you discover?
I found a Caucasian male, approximately 50 years old. He had been stabbed 1 centimeter below his left inferior scapular angle, just about right here, and had died of exsanguination. He bled out.
Let's talk about how you began your investigation. How did you start your investigation of the crime scene?
I started working backwards. After examining the victim at his front door, I noticed there was blood droplets leading back to the kitchen, so I followed them.
What did you discover in the kitchen?
In the kitchen, I found several relevant pieces of evidence: a knocked over chair, an open knife drawer, a knife missing from the knife block, a broken plate. All of this evidence clearly indicated that a struggle had occurred.
After investigating the kitchen, where else did you go?
After investigating the kitchen and clearing the inside of the house, I began looking around the outside of the home.
What did you discover on the outside of the home?
I found 3 different Ring security cameras, one at the front door, one by the side gate, and one at the back door.
What can be seen on these Ring videos?
In these Ring videos, you can see someone wearing a mask covering their whole face, a big hoodie covering their as much as they could, and gloves. Try to enter through the front door, but when they were unsuccessful, move around through the side gate and enter through the back door.
What was the general height and build of the intruder in the video?
The general height and build is the exact same height and build as the defendant here today.
Thank you, Detective. Pause for one moment, if you would, please, sir. Ms. Damiana, what's your objection, please?
I believe that this witness is testifying to fact, not in evidence, and I would ask that the prosecution enters these videos into evidence before proceeding any further.
Your Honor, may I respond?
You may, Mr. Powell. Go ahead, sir.
Your Honor, pursuant to Rule 703, experts recognized by this court can testify to things that aided in the facts or data that aided in their opinion. Detective Markowitz testified that this was part of his investigation, these Ring videos. Therefore, Detective Markowitz can testify about the contents of those rather than admitting them.
All right, let's do it this way, counsel. I'm going to sustain the objection in part as to foundation. So if you can, I'll have you lay a little bit about generally where the videos are from, when you analyze them, et cetera, to the extent you have that information. I think we do need a little bit of foundation before we delve right into the material. So I'll sustain it in part. If you could lay that foundation, counsel, you're free to go.
Detective Markowitz, did these Ring videos aid in your expert opinion?
Yes, sir, they did. When I downloaded the contents of them with regards to March 6th, they showed me all the things that I testified to.
Your Honor, is that sufficient foundation?
It is for me. We'll see if your opposing counsel has an objection as you proceed through, but you're welcome to go ahead with that, counsel. Thank you.
Detective Markowitz, I'll ask that again. What was the general height and build of the person in the video?
The general height and build was the same as the defendant here today.
Let's talk about how you found the person in the video. How did you begin your investigation of possible suspects?
I started by downloading and analyzing the contents of Mr. Brackman's phone. I discovered that he was involved with mock trial at Colorado High School, and judging by the number of emails and texts he received, he was extremely involved. Through this involvement, I was able to get in touch with one of the members of the team, Alex Cifuentes.
What did you learn from Alex Cifuentes?
After a call and an interview with Ms. Cifuentes, I found out that the defendant had recently vandalized Mr. Brackman's car and was removed from the team for it. Then the defendant, in an attempt to be reinstated, texted Ms. Cifuentes asking for help.
Detective Markowitz and Ms. Damiana, please direct your attention to Exhibit 14. Detective Markowitz, what is Exhibit 14?
This is a copy of the screenshots Alex Cifuentes sent of the text messages with the defendant.
Are these a fair and accurate copy of those screenshots?
Yes, sir, they are.
Your Honor, the people request Exhibit 14 to be admitted to evidence for its accuracy and authenticity have been shown.
What's the defense's position on admission of the exhibit?
Your Honor, the defense would like to object under Rule 901A and Rule 1003. Under 901A, I don't believe that these have been authenticated. There is no date nor a phone number attached, so we can't know that it's between Cifuentes or Avery Becker. And under Rule 1003, admissibility of duplicates, the original's authenticity is under question.
May I respond, Your Honor?
You may.
Your Honor, pursuant to Rule 901B1, this is testimony of a witness with knowledge. Detective Markowitz has testified that this is what he claims it is to be. And furthermore, pursuant to Rule 1004A, the originals were lost and not in bad faith of the proponent.
I'm going to overrule the objection. Will allow Exhibit 14 to come in. I will give that with the jury instruction, though, as we get to the end of it, sort of about the nature of that text message, particularly if the defendant doesn't testify. You can proceed with that, counsel.
Your Honor, permission for Ms. Sayers to publish Exhibit 14 to the jury.
Granted. Thank you.
Detective Markowitz, what on these text messages furthered your investigation?
There are two texts in particular that caught my eye. The first one being, well, if he's upset about his car, then he's going to be really upset when he sees what I do to his house. The second one being, I'm going to wait until he's at work, then break in and trash it.
Thank you, Ms. Sayers. Detective Markowitz, other than that, what else led you to suspect the defendant?
Upon further examination, the call detail records provided information about the location of the defendant's phone on the day of March 6th.
What are call detail records?
Call detail records, or CDRs, are accurate records of when phone calls or text messages were sent or received to a specific phone.
Detective Markowitz and Ms. Damiana, please direct your attention to Exhibit 16. What is Exhibit 16, Detective?
This is a copy of a map that I overlaid with cell towers and their arcs.
Is this a fair and accurate copy of that map?
Yes, sir, it is.
Your Honor, the people request that Exhibit 16 to be admitted to evidence for its accuracy and authenticity have been shown.
Does the defense have a position on the admission of Exhibit 16?
We have no objection.
Exhibit 16 is admitted. You can proceed, counsel.
Your Honor, permission for Detective Markowitz to screen share Exhibit 16 to the jury.
Granted.
Detective Markowitz, can you show us what this map shows or what it means?
Yes, sir. First, looking at this tower that I'm circling in blue. The first ping was made at 12:47. This tower covers the defendant's home. The second ping was made to this tower I am now circling at 12:55. Notice how the sector for this tower in which the phone pings in does not cover the mall nor the fry shack, but rather a possible route that the defendant took to get to the victim's home. Then, thirdly, this tower at the bottom, the one covering the victim's home, pings 3 different times, 13:05, 13:06, and 13:17.
Detective Markowitz, what does the defendant's phone pinging 3 times at near the victim's home show?
This clearly indicates that the phone was within that area. Because of the repeated connection to the same sector of the cell tower arc, it clearly indicates that the phone was within that vicinity.
Detective Markowitz, thank you. You can stop screen sharing now. Let's talk about your conclusions. Have you formed an expert conclusion in today's case?
Yes, sir, I have.
And in light of all your experience and the evidence, what is that conclusion?
In my expert opinion, first the intruder tried to enter through the front door, but was unsuccessful. So she moved around to the back door through the side gate and was able to unlawfully enter the home of Mr. Brackman, in which events ensued that ended with Mr. Brackman being stabbed, moving to his front door, falling, and bleeding out.
Why is that your assessment?
Looking at the totality of the evidence in this case, I was able to make that conclusion.
And who can you conclude the intruder was?
I can conclude that the defendant, Avery Becker, was the intruder in this case. Looking at all the evidence, especially the text and the towers, allowed me to make this conclusion.
Can you identify the defendant here today?
Yes, sir, I can. She was the one on introductions who you saw had the light hair and the light blue blazer.
Thank you, Detective. Your Honor, I have no further questions at this time.
Thank you, counsel. Let's proceed with cross-examination from the defense, please.
Thank you, Your Honor. Detective Markowitz, upon your initial investigation into Mackenzie Brackman's death, you found that Mackenzie Brackman was involved as the coach of the CHS mock trial team?
Yes, ma'am, I did.
And at first, you thought it seemed highly unlikely that Brackman's activity with the mock trial team had anything to do with his death.
I did not know whether it would, so I decided to pursue it just in case, and it did lead me to my biggest break within this case.
Yes, and you investigated this lead and called one of its members, Alex Cifuentes?
Yes, ma'am, I did.
Cifuentes was the only member that you actually spoke to.
He was the one that gave me the break with the text messages, and I did not pursue any other students on the mock trial team, as I received all the information from Alex Fuentes.
You never spoke with Taylor Perkins?
No, ma'am, I did not.
You never spoke to any of the other 9 members of the mock trial team?
No, ma'am, I did not.
One of your other initial theories led you to believe that Mr. Brackman could have been murdered by a former client.
When finding out who the victim was in this case, it did raise the specter that it might be a disgruntled ex-client. However, this theory was disproven.
And you reviewed the evidence in this case, including that of your colleagues?
Yes, ma'am, of course I did.
You were aware then of a student named Blair Rollins?
I am aware of that. In fact, I included him on my exhibit, Exhibit 16, as I showed previously.
Yes, I did see that, Detective, but you never spoke with Blair Rollins.
No, ma'am, he was unably contacted.
And you never checked his attendance records on the day of the murder, is that correct?
No, ma'am, I did not.
You never even tried to find him since the day of the murder?
I did try to find him, however, I was unsuccessful.
And you never investigated any other former clients of Mr. Brackman?
No, ma'am, I did not. There was no connection between the evidence in this case and any other client. See, it's my job to follow the evidence, not make suspicions and then make the evidence fit that.
Detective, I'm not asking about if you thought it was necessary or not. I'm asking if you investigated any other former clients.
No, ma'am, I did not.
And you never went to Mackenzie Brackman's office to examine his files?
No, ma'am, I did not.
You never got a list of people that he represented either?
Of course I didn't, ma'am.
Now, moving into your area of expertise, you are aware that a cell phone will not always connect to the nearest tower?
Of course I'm aware of that. It connects to the tower with the best service. And in instances of high cell tower traffic, it might not connect to the closest one. However, that is extremely rare.
So to be clear, Detective, even if a cell phone is far from a tower, it may still connect with it?
If it is within the cell tower's range, which in the best possible scenarios is 6 miles. In this case, the cell tower is only spanned out about a mile. So it would have to be within that radius.
So even if Avery Becker's phone was far from a cell tower or not exactly in the arc radius, there is a possibility her phone could have still connected to it?
Highly unlikely, but there is always a possibility.
Fantastic. And you concluded that a number of calls were placed by Taylor Perkins on March 6th. Is that correct?
Yes, ma'am, I did.
But you never investigated into the call records of Taylor Perkins.
Of course I didn't, ma'am. That would show nothing.
Now, shifting focus, detective, you received screenshots of a text conversation with Alex Cifuentes,
Yes, ma'am, I did.
but you never took out a search warrant for Cifuentes' phone yourself?
Of course I didn't.
You never even looked at Cifuentes' phone yourself?
No, ma'am, of course I did not do that.
You never got Cifuentes' phone records?
Ma'am, I interviewed Alex Cifuentes, and there was a credible report of a threat, a credible interview, and credible screenshots. Of course I didn't.
Now, this is something that you did do with the defendant, Avery Becker's phone. Is that correct?
Ma'am, I was never given access to Avery Becker's phone.
But you did get his call detail records.
I received his phone number, and through that, I went to the cell towers to find the connections.
Now, the only evidence you have of the text messages are screenshots from Alex Cifuentes.
Yes, ma'am, that's correct. And his word for it in the interview, and his call with me before the interview.
Thank you, detective. And these screenshots were sent to you by Cifuentes himself?
Yes, ma'am.
These screenshots do not show the date of the text messages. Is that correct?
They do not show the date.
And they do not show the actual phone number that the texts are from?
Just a contact, which is Avery Becker.
Yes, thank you, detective. Your Honor, I have no further questions.
Thank you, counsel. Would the people like a redirect?
Yes, Your Honor.
You may proceed.
Detective Markowitz, why wasn't Alex Cifuentes' phone searched?
Sir, I had a credible call with him before the interview, a credible interview, and a credible
Objection, Your Honor.
What's the objection, counsel?
Speculation. I don't believe this expert witness can testify to the credibility of Alex Cifuentes, as their expertise is in police investigation and cell phone forensics.
Response from the people.
Your Honor, this is not speculation. Detective Markowitz has been recognized by this court as an expert in forensic data recovery, and as part of that entails credibility of data, and therefore this is not speculation.
I'm going to sustain the objection, counsel. I think your detective can testify as to what he observed or saw. I think that evaluations as to credibility are most appropriately left to the jury.
Detective Markowitz, based on what you observed, why did you not take the Alex Cifuentes' phone?
From my interview, call, and the screenshots themselves, of course I didn't download the contents of his phone. There was no need to.
Thank you, Detective. Your Honor, I have no further questions.
All right. Anything else from the defense on that, or are we all set?
All good, Your Honor.
Thank you. Do the people have another witness to call?
Yes, Your Honor. May Detective Markowitz be excused?
He may, yes. I apologize. Thank you, Detective
Thank you, Your
Markowitz. We
Honor.
appreciate your testimony.
The people call Kyle Kuzak to the stand. Good morning, Mr. Kuzak. Oh,
Bear with me one quick moment, Ms. Proctor. I'm going to swear your witness in. Mr. Kuzak, if you would please raise your right hand and repeat after me. Do you swear do you swear under penalty of perjury that the testimony you are about to give is the truth, the whole truth, and nothing but the truth, sir?
I do.
Excellent. Thank you, Ms. Proctor. You may proceed.
yes, Your Honor. Good morning, Mr. Kuzak.
Good morning.
My name is Madeline Proctor. Please introduce yourself to the jury.
I am a Colorado Bureau of Investigation. My apologies. I am Kyle Kuzak, last name spelled Kuzak.
Mr. Kuzak, what do you do for a living?
As I was saying, I am a Colorado crime scene reconstruction investigator. For simplicity's sake, we're typically known as CSRs.
And what does being a CSR entail?
It's actually a very interesting job. Crime scene reconstruction is an interdisciplinary field involving biology, say when looking at bodies and blood cast off, or ballistics and physics when examining bullet holes and shell casings. CSRs like myself use this sort of specialized knowledge to help put together the evidence from potential crime scenes.
What do you mean by potential crime scenes?
I deliberately use the word potential because the evidence doesn't always point to the commission of a crime. Sometimes my investigations reveal that what looks like a crime scene at first glance is actually a result of a fatal accident where no crime was committed.
So, Mr. Kuzak, what sorts of crime scenes do you work on?
Well, there's actually no one single kind of crime scene I work on. I've worked on a multiplicity of cases, anything from property crimes like home invasions and burglaries to violent crimes like homicides, domestic violence cases, and armed robberies.
And in your reconstruction, who do you work for?
Currently, I am working for the Denver Police Department as a civilian employee. I've been with them for the past 3 years.
Were you working for anyone else before?
Yes, actually, I have over 19 years of experience as a CSR, working for different police departments across Colorado.
Your Honor, at this time, the people request the court to recognize Mr. Kuzak as an expert in the field of crime scene reconstruction. Pursuant to Rule 702, his skill, knowledge, experience, education, and training have all been shown, and his testimony will assist the jury in understanding the facts of today's case.
For the defense, what's the position on the people's proposed tender?
Commission of Auditor, Your Honor.
You may.
Thank you. As you said, you are not a police officer, is that correct?
No, I'm not.
You're a civilian employee of the police department?
That is correct.
So
CSRs typically are.
You haven't been through the same basic training that all police officers go through?
I'm not a police officer, so I do not have to go for that basic training.
Or say the same training that a police investigator might go through?
Well, some police investigators do actually get certified by the Colorado Bureau of Investigation, and they have certified me as a CSR.
But you've not been through the same training that a police investigator might go through?
Not the exact same training as every single police investigator.
Thank you. Your Honor, I object to the witness's qualification on the grounds that they do not have the same or equivalent training as a police officer or police investigator, who might typically be offered as a CSR in a case such as this one.
Response, Your Honor?
You may.
Crime scene reconstruction is a highly specialized field, more specialized actually than police investigation or general police practice. So I believe that under Rule 702, only skill, knowledge, experience, education, or training is required. And Mr. Kuzak has demonstrated all 5.
Thank you, counsel. And far be it from me to disagree with the bureaucratic agency that's issued a certification. I'm going to accept the tender and allow Mr. Kuzak to testify as an expert in crime scene reconstruction. Ms. Proctor, you may proceed.
Yes, Your Honor. Mr. Kuzak, is there a method that you typically follow?
I, along with all other experts in my field, use a tried and true process, Ross and Gardner's 5-step method.
Tell us more about Ross and Gardner's method.
It's a 5-step process centered around analysis of evidence. In step 1, recognition, I map out the basic facts of the case, as well as the witnesses involved. In step 2, collection, I work alongside the police to collect evidence. In step 3, analysis of evidence, I begin to put this evidence together to form probable event segments. Afterwards, in step 4, hypothesis and testing, I test out broader...
Mr. Kuzak, what's your objection, counsel?
This question has created a narrative.
Response, Your Honor?
Yes, counsel.
This is not narrative, as this is directly responding to the question asked, which is about Ross and Gardner's method. And Mr. Kuzak is simply divulging the steps of his method. This is directly relevant to the question.
I certainly agree with you that it's relevant, counsel. What you may want to do is inquire more in a line of questioning. What's the first step? What's the second step? I think we're all the way through 1, 2, and 3. So you may want to wrap it up with the witnesses to the last step. I agree. It was a little bit of a narrative, not necessarily a problem with the question, just in terms of the volume of the answer. So let's break it up a little bit. You can go ahead.
Yes, Your Honor. Mr. Kuzak, tell us about step 4.
Step 4 would be hypothesis and testing. In this step, I test out broader theories about the case based on those aforementioned probable event segments.
What about step 5?
And step 5 is, as my job title implies, reconstruction.
I see. So let's apply that method to today's case. How did you go about mapping out the evidence?
In step one, recognition, I didn't just map out the evidence in a couple spreadsheets and flowcharts. I also mapped out evidence ID numbers and the witnesses involved.
What about step two?
That would be a collection of evidence. I was able to visit the crime scene firsthand on the day of the murder after it was processed by the police team. Detective Markowitz also later sent me all of the evidence that the police used in their own investigation.
All right, and how did you analyze that evidence?
I analyzed that evidence by expanding the organizational framework by step one and testing out various bits of evidence in a scientific process.
Okay, Mr. Kuzak, what evidence did you use to reach your reconstruction?
There was evidence all over the bottom story of the house. Firstly, there were scuff marks near the back door. There was a knocked over chair, a knife block, and an open knife drawer in the kitchen. As I moved further through the house, I saw blood cast off, and then by the front door, there was the body of Mr. Brackman along with a bloody knife.
All right, let's walk through your reconstruction a little bit. Let's starting with the victim's body and the bloody knife. What did that evidence tell you?
Together, these two pieces of evidence revealed three important facts about today's case, namely that Mr. Brackman was stabbed, that he died of exsanguination after removing the knife from his back, and that the knife found near his body was used to kill him.
And do you know where that knife came from?
It is my conclusion that that knife came from the knife block. However, it is also possible that it came from the knife drawer.
Why did you conclude that it came from the block?
The handle would have been easily accessible in the block. It would have been more prominent in the block, and it makes sense that the empty slot would have been filled at some point.
Does it matter whether it came from the block or the drawer?
I'm very meticulous about my reconstruction, so it does matter to me. However, what really matters is that either way, it came from inside the house.
And why does that matter?
The fact that the knife came from inside the house shows that the intruder did not bring the knife himself or plan to use a knife. This reinforces my conclusion that the crime scene was the result of a burglary gone wrong and not something more sinister.
All right, Mr. Kuzak, so now we're in the kitchen. What evidence did you find there?
Aside from the open knife drawer knife block, there was also a knocked over chair, a broken plate by the kitchen, and some scuff marks near the back door.
And what did that show you?
Independently, these pieces of evidence don't actually show much. However, in combination, they revealed to me that an altercation had occurred.
Tell us about that altercation.
Mr. Brackman tried to stop the intruder from entering the home, creating the scuff marks. As they fought in the kitchen, they knocked the plate onto the ground, breaking it.
These scuff marks could have been created at any point during the many years which Brackman lived at his house. I don't believe there is any way that the witness could know that they were created during the day of the murder.
Response.
Director, the objection is to speculation. Your response, please.
Mr. Kuzak is an expert in crime scene reconstruction, so as such, he has experience in drawing conclusions from the evidence in what has actually occurred on the day that takes place. So this is part of his opinion on what the evidence shows at the crime scene. I believe that that would be better explored on cross-examination.
I'm inclined to agree with you, Counsel. Mr. Littlewood, I think that's definitely information that the jury would be curious to hear on cross, ripe for that opportunity there. Counsel, you can go ahead and resume your examination.
So, Mr. Kuzak, what was that altercation?
As I was saying, Mr. Brackman attempted to stop the intruder from entering the house, creating the scuff marks. And as they fought in the kitchen, they knocked over the chair and knocked over the plate.
All right. You also said you received some evidence from the police. What was that?
Detective Markowitz sent me footage from the free ring security cameras around the property.
What did the videos show?
The videos showed me the height and build of the intruder's progression around the house, and the fact that the intruder was even picked up on camera means that Mr. Brackman would have been alerted by the security system.
So, Mr. Kuzak, let's skip ahead to your final step. Were you able to reconstruct what happened?
Yes, I was.
Mr. Kuzak, reconstruct March 6th for us. What happened?
Objection, Your Honor. This question calls for a narrative answer.
Response, Your Honor.
Go ahead, Ms. Proctor.
I believe that he has laid the foundation for what occurred on March 6th throughout, and this is just presenting that evidence as a whole in his reconstruction, which is the basis of his entire work.
So, Counsel, to me, that actually sounds like we've got two issues. The first is the narrative objection, and the second is to the cumulative nature of the testimony. I'm going to give you a little bit of latitude with Mr. Kuzak to sort of wrap this up and close a loop. At the same time, Mr. Littlewood, if that answer gets any more extended than I think a quick summary of the testimony, I definitely entertain another objection as to narrative, and we'll have to break it up at that point. The other part is the witness has already testified to most of this. We've got a time limit, so let's make it brief if we could, please.
Mr. Kuzak, please briefly summarize what happened on March 6th.
The intruder walked up to the front door and, finding it to be locked, proceeded around the side gate and in through the back door. Mr. Brackman was alerted by his ring security system and so grabbed a knife to fend the intruder off. They struggled. Mr. Brackman was stabbed and he bled out near the front door of his home.
Thank you, Mr. Kuzak. And in light of that reconstruction, you said earlier that not all of your reconstructions result in a crime having been committed. Is that applicable today?
No, it is not. In this case, the evidence was relatively simple, and it led me to a relatively simple conclusion, namely that Mr. Brackman's death was the result of a burglary gone wrong.
Thank you, Mr. Kuzak. Your Honor, I have no further questions at this time.
Thank you, counsel. Mr. Littlewood, cross-examination. You can proceed.
Thank you, Your Honor. I'm going to start with some questions about the security camera footage. You are aware that push notifications can be turned off on the Ring app?
I'm aware that they can be turned off, yes.
And you did not obtain records from Ring to see if the victim had disabled push notifications?
The physical evidence at the scene indicated that he did receive the push notifications.
That's a no. You did not obtain records from Ring to see if he had disabled them?
No.
And you reviewed Professor Blake Van Owen's report for this case?
That is correct, I did.
So you are aware of Blair Rowland's involvement as a possible suspect?
I mentioned him in my witness tracking sheet, yes.
Yes, and you actually regarded him as a suspect as well?
It was provided as a suspect to me by the police.
And you learned that the victim in this case represented Blair Rowland's father in a separate case?
Yes, however, again, this is outside my specialty as a CSR. I can't speak much to the specifics of the different suspects.
But nevertheless, you learned that at that trial, their father was on trial for murder.
I learned some of the basic information about what made him suspect Blair Rowland's the suspect, yes.
And through the course of that trial, he was sentenced to life in prison.
Yes.
But neither you nor anyone else at the police department ever checked Blair Rowland's attendance records for the day of the murder.
Mr. Littlewood, I am a CSR. I reconstruct a crime scene. I don't investigate suspects.
But you work with the police.
As a CSR.
And if the police had checked Blair Rowland's attendance records, you would likely be aware of this, wouldn't you?
It would have been included in information the police sent to me.
And no one at the police ever checked Blair Rowland's attendance records for the day of the murder?
I do not know. As you said, I'm not an actual police officer. I'm a civilian consultant.
Thank you. Moving on. Now, you also used a flow chart to keep track of case details for this case, as you mentioned?
Yes, that is correct.
And as noted on the flow chart, many of the details on that flow chart are details you learned in an interview with Detective Markowitz.
Yes, I work very closely with him.
Now moving on to some of the material evidence, it is your opinion that the knife the victim was stabbed with came from the knife block in the kitchen.
That is correct.
And this knife had a silver blade and handle cast from one piece of metal.
Yes.
And the knives in the knife block all have black plastic handles.
If you're speaking to the discrepancy between the knives, I can say that the knife used to kill Mr. Brackman was a Chicago cutlery knife, and the knives in the knife block were J.A. Henkel.
I merely asked, the knives in the knife block had black plastic handles, is that correct?
Yes, they had a different physical appearance, that is correct.
And as you just mentioned, the knife that was used as a murder weapon was a Chicago cutlery knife?
Yes, that is correct.
Meanwhile, the knives in the knife block were from a J.A. Henkel's knife set.
Yes, I did just say this.
So the murder weapon was a different color than the knives in the knife block.
The blade was silver. You could say that the handle was a cast piece of metal as opposed to the plastic handles of the J. Henkel knives.
So they had different colored handles.
Yes.
And they were generally a different style.
Please elaborate on a different style.
A different style of make, one with a plastic handle, wherein the whole knife is not made.
As I said, the makes were different and the appearances were different.
Thank you. And they were a different brand.
Yes.
Thank you, Your Honor. I have no further questions at this time.
You redirect for the people.
Yes, Your Honor. Mr. Kuzak, did the style of knife affect your conclusion?
It affected my reconstruction, however, it did not affect my ultimate conclusion.
Why would it affect your reconstruction, but not your ultimate conclusion?
I had to specifically consider why did this discrepancy between the knives in the knife block and the knife used to kill Mr. Brackman. However, the rest of the physical evidence at the scene, the totality of the evidence, again, the fact that there was an open slot for a knife the size of the Chicago cutlery knife and immediate accessibility of the knife block, did lead me to believe that the Chicago cutlery knife came from the knife block.
Does it matter whether the knife came from the block or not?
It matters that it came from inside the house. It could have come from inside a drawer, where there are knives of many different makes and styles.
Mr. Kuzak, whose job is it to investigate suspects other than investigate suspects in this case?
That would be the job of the Denver Police Department, specifically Detective Markowitz.
Thank you, Mr. Kuzak. Your Honor, I have no further questions at this time.
Thank you, Ms. Proctor. Mr. Littlewood, anything else for this witness?
No, Your Honor.
All right, thank you. Ms. Proctor, may we excuse your witness from the stand?
Yes, Your Honor.
All right, any additional witnesses for the people at this time?
Yes, Your Honor. The people call Alex Cifuentes to the stand.
All right, and if you would please, we'll have the witness raise their right hand. And do you swear or affirm under penalty of perjury that the testimony you are about to give is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Excellent. Thank you, counsel. You may inquire.
Good morning, Ms. Cifuentes. My name is Feliciana Sayers. Please introduce yourself to the jury.
Good morning. I am Alex Cifuentes. That's Sifuentes.
Let's start with Avery Becker. How do you know her?
Avery and I were on the mock trial team, specifically the A team, and she actually got me to join when I was a freshman.
You mentioned mock trial. What is mock trial?
Mock trial is so much fun. It's like a bunch of nerds hanging out. You have a team, and some people are lawyers, other people are witnesses, and then we go to the local courthouse and try the case with a real judge. Well, unless you're in a global pandemic, then I guess you go to Zoom.
That sounds like a lot of fun, Ms. Cifuentes. How did Ms. Becker fit into your mock trial team?
Avery was a lawyer, but she constantly showed up late and unprepared.
How did that affect the team?
It causes a lot of anxiety, especially in going into important tournaments like regionals.
Let's talk about Coach Brackman. Who was he to you?
Coach Brackman was an amazing coach. We both believe that working hard was the way to succeed. I actually think he saw a bit of himself in me at times.
Objection, speculation. This witness is just testifying to the inner thoughts of the victim in this case, and therefore it is speculation.
Sayers.
Response, Your Honor.
Go ahead, counsel.
Your Honor, pursuant to Rule 701, this witness is testifying to her rationally based perceptions on what Coach Brackman's work ethic and what he saw in her. She prefaced her statement by saying, "I think." She is not speculating. She is only saying what she thinks she knows.
I'm going to overrule the objection. Counsel, you can go ahead and proceed.
Ms. Cifuentes, who was Coach Brackman to you?
He was my mentor. I looked up to him. I wanted to be like him when I grew up. It's really hard knowing that he's gone. I just really miss him.
Ms. Cifuentes, I understand this is hard for you, but we need to continue. What was Coach Brackman and Miss Becker's relationship like?
It wasn't the best, to say the least. There was just a lot of tension, and they would argue almost every practice.
What were some of those arguments?
Well, most of the time it was over minor things, like Avery being late or stuff like that. But the first argument that really blew up was when Avery got demoted to the B team after she showed up late to practice for like the millionth time. Like, what was she doing? Getting Starbucks?
Was Miss Becker ever reinstated back on the A team?
Yeah, when her sidekick Taylor Perkins quit.
Who is Taylor Perkins?
You know Batman and Robin? Well, Taylor's Avery's Robin. He's just the sidekick.
Were there any other incidents between Coach Brackman and Miss Becker that you can recall?
Yeah, specifically after the regional tournament, Coach was just briefing us, telling us how it could be better, especially going into state. And when it was Avery's turn, Coach was telling her that she needed to work harder, that she was unprepared, that what she did could be considered malpractice in the real world. And Avery blew up and stormed out of practice.
What did Miss Becker do after she stormed out?
She took a marker and wrote Worst Attorney Award on Coach's car.
What was Coach Brackman's response?
He kicked her off the team, of course. He was the coach of the mock trial team, and vandalism is illegal. Of course he was going to have some issues with it.
Now, Mr. Fuentes, let's talk about the text messages you received from Miss Becker. Your Honor, I request that Mr. Powell pull up Exhibit 14.
Excellent. We've already admitted Exhibit 14, counsel, so you may proceed with your examination.
How do you know that Miss Becker sent these text messages?
Avery and I were really good friends, so we texted a lot. It was my phone, her name at the top, plus she said, "Hey, Alex, it's Avery."
What did you do with these?
Cumulative evidence. This piece of evidence has been admitted through Detective Markowitz and explained in detail, including the contents of the messages. Therefore, going into further detail is simply cumulative. The exhibit should speak for itself.
And I'm going to overrule that objection, counsel. One of the issues that was raised with respect to the admission of this exhibit was the authentication as to whom the text messages were from and how we know that they got to the individuals they got to. That's what this witness is testifying to. As that was part of an objection that the defense made, I'm going to let the people go into it. I think that's information that the jury just need to hear. Ms. Sayers, proceed.
Mr. Fuentes, what did you do with these text messages when you received them?
At first, I didn't do anything. I just thought it was another one of Avery's tantrums. But once Coach died and I realized how important they were, I gave them to the proper authorities.
What did the proper authorities do with them?
Well, after hearing Detective Markowitz's testimony today, it sounds like he used them for his investigation.
Did Detective Markowitz reach out to you for these text messages?
Yes, he called me at first and we discussed some things, and then he later called me in for an interview.
What happened at that interview?
He started off with just asking me some questions. I guess they were things about the case. And then he moved into the text messages and I realized I forgot my phone at my house. Its battery's not the best. I left it plugged into the wall. I offered to get it, but he said screenshots were fine.
Let's talk about the content of these text messages. Did any of these texts stand out to you in particular?
Objection. I'm going to make the same cumulative objection. Once again, the contents of the messages have already been gone over. Although authenticity is a different question, in this case, the question calls for the content, which has been covered by Detective Markowitz.
Ms. Sayers, response.
Your Honor, this is a different witness. This is not Detective Markowitz. Ms. Fuentes is testifying as to what she received in these text messages. These are the texts of Avery Becker, and she is simply testifying to that.
Different witness, but the same exhibit, correct?
Yes, Your Honor.
I'm going to sustain the objection. Let's move on. The jury already has the exhibit. They can read the text messages, and it's published presently. Go ahead.
Mr. Fuentes, did Avery Becker say anything in these text messages that alarmed you?
Objection. I'm going to make the same cumulative objection. It's the same.
I'll pause you there, counsel. That question I actually think is relevant for the jury. If there's something in here that speaks to Ms. Fuentes' state of mind, I think we'd like to hear it. Ms. Sayers, go ahead.
Mr. Fuentes, were there any text messages that Ms. Becker sent to you that concerned you at all?
Yes, there was. There's a specific one where Avery makes a direct threat at Coach. She says, well, if he's upset about his car, then he's going to be really upset when he sees what I do to his house.
Thank you, Mr. Fuentes. Your Honor, I have no further questions at this time.
All right. For the defense.
Yes, Your Honor. Hello, Mrs. Fuentes. I'm glad you're here. I also appreciate the enthusiasm, especially in a murder trial. You went to CHS and you were on the mock trial team with Avery.
I was the A team.
And all 3 years.
Of course. I was really good. I worked really hard.
Impressive. That's great to hear. And all that time you must constantly be around Mrs. Becker.
Yeah, we were really good friends. We were homies.
I mean, you thought you were basically best friends.
Yeah.
And despite this, Avery had a lackadaisical attitude towards mock trial in your eyes.
She was constantly unprepared and showed up late to practice. I would say so.
And it was you who even asked Coach Brackman why he even put up with her.
There was a lot of tension. I could tell it was taking a toll on him. Of course I did.
And after a dispute between Brackman and Avery, Avery wrote on his car with a marker.
She vandalized his car, writing Worst Attorney Award, yes.
But did Brackman press charges of vandalism against her?
No, and he's a really good person for doing that. That could have really hurt Avery.
But it was you who wished he did.
I thought he should have, because it is vandalism, it is legal, but he's a good guy. He didn't.
And after she was kicked off, your best friend reached out to you for getting back on the team.
Of course she would. We were good friends.
But it was you who didn't even want her back.
I thought that going into state, her being unprepared might have hurt us, but at the same time, the whole issue with not being able to replace her for state, it made sense for me to go advocate for her. Plus, I said I would. She's my friend.
The relationship with Avery is a little unclear, but definitely with Coach Brackman, you thought very well of him.
Of course I did. He was a talented litigator.
He's not only a talented litigator, but you also really cared about him as a person.
Of course I did. He was my mentor, I would say.
So when Avery apparently texted you a plan to trash his house, you must have warned the police, seeing as you cared for Brackman so much.
I didn't. I thought it was just one of Avery's tantrums, or just, Avery being Avery. I didn't realize how severe it was.
You might not have warned the police, but you must have warned at least Coach Brackman.
I didn't. I just thought it was just Avery speaking in the heat of the moment, but I didn't realize what she could do.
So you cared about Brackman, but you didn't warn the police or Coach Brackman about a potential crime. As you said, vandalism is illegal.
I didn't know how important it was then, but I wish I would have.
Either way, Avery apparently admitted to you that she was planning on a vandalism at Brackman's house through text.
She did. She threatened Coach in it as well.
And you attended a police interview for these texts.
I did.
And they wanted them, and they were clear about that.
Well, Detective Markowitz, yes, he did ask me for them, but I did send him the screenshots later on, the next day after the interview.
So you didn't bring your phone?
Its battery's not the best. I actually had to get it replaced. I left it at phone plugged into the wall, silly me, but I offered to get it.
So you cared about Coach Brackman and getting to the bottom of the case, but you didn't even bring one of the most key pieces of evidence that the police wanted.
I wish I would have brought it, but I still made sure that Detective Markowitz got the text and everything he needed.
So when you got home, you sent the screenshots, which they accepted.
Yes, they did.
But do you have the phone with confession now in case they need it?
I don't. Again, my phone was not the best. Its battery was not it, so I had to get a new one. It's probably somewhere in an Apple thing.
No further questions, Your Honor.
Any redirect for the people?
Yes, Your Honor.
You may proceed.
Mr. Fuentes, what is your relationship with Avery Becker?
Avery and I were really good friends. We were almost best friends. That is until she killed Coach Brackman.
Objection, speculation. This witness cannot comment onto the final conclusion of this case just based on her feelings about what Avery did.
Ms. Sayers' response.
Your Honor, pursuant to Rule 701, this witness is allowed to testify on a rationally based perception. And she is not saying that, the weight of her testimony is up to the jury, whether or not Ms. Becker killed Coach Brackman. She is simply stating her opinion.
I'm going to sustain that objection. I actually think that's probably overly prejudicial. The jury does have the weight of the testimony when they take it back to deliberations. You may resume, Ms. Sayers.
Ms. Fuentes, why didn't you do anything with those text messages when you first received them?
I didn't realize how important they were then, or what Avery was going to do or could have done. I didn't know how important they were at the time. I wish I would have done something then, and maybe I could have saved Coach.
And Ms. Fuentes, why didn't you bring your phone to the interview?
I left it plugged into the wall, and it was a stupid mistake. I was charging it so its battery would have had as much as it could go, so I could give it to Detective Markowitz. But I remembered to give him screenshots, and I gave him as soon as I could.
Thank you, Ms. Fuentes. Your Honor, I have no further questions.
For the defense, anything else that we need to follow up on for this witness's testimony?
No, Your Honor. The defense rests.
May the witness be excused then for the people.
Yes, Your Honor.
All right. Any additional witnesses for the people at this time?
No, Your Honor. At this time, the people rest.
All right. Before we jump into defense witnesses, anything we need to take care of before we get that process started? Mr. McKinney.
Not at this time, Your Honor.
All right. Well, I do have one personal item to take care of here, folks. Unfortunately, I made a bad decision and opened a Diet Coke immediately before we got started with our round here today. So if you bear with me for about 2 minutes, I'm going to run to the washroom. I will pop my camera back on. If anybody else needs to use the time, you're welcome to. It's currently 10:34. I don't expect to be any delayed after 10:37. So bear with me for just a few moments. We'll be right back in and get started. Okay, folks, thank you for your indulgence. I appreciate it. If everybody is ready to jump back in, I believe I need to inquire with the defense as to whether or not they are intending to call any witnesses and present evidence.
Yes, Your Honor. Our first witness is Avery Becker.
And counsel, if we could, please, I just want to make sure that we're pronouncing your last name correctly. Will you tell us how to say it, please?
Damiana, Your Honor.
Damiana. All right, excellent. Thank you, counsel. You may call your witness.
Absolutely. The defense would like to call Avery Becker to the stand.
All right, Ms. Becker, normally the judge do an enormous amount of advising with you about your Fifth Amendment right against self-incrimination. We'll spare you all of those details. I will have you, though, if you would please raise your right hand. I'm going to swear you in. Ms. Becker, do you swear to tell the truth, the whole truth, and nothing but the truth, understanding that your testimony today is given under penalty of perjury?
Of course, Your Honor.
And I suppose I should just ask you, you do understand that by virtue of taking the stand, you will be cross-examined by the prosecutor in this process. You understand that, correct?
Yes, Your Honor, I understand that.
All right. Ms. Damiana, you may proceed. Thank you.
Thank you, Your Honor. Good morning, Ms. Becker. Would you please state your name and spell your last for the record?
My name is Avery Becker. Becker is spelled Becker.
Fantastic. How old are you, Ms. Becker?
I'm 18 years old. I graduated from Colorado High School last year.
And how did you know the late Mackenzie Brackman?
Mr. Brackman was my mock trial coach during my time in high school.
How long were you on the mock trial team coached by him?
I participated in mock trial for all 4 years. It was something I really enjoyed.
That's a long time. Why did you join the mock trial?
Well, originally I actually joined because I wanted to hang out with my friend Taylor Perkins and have an opportunity to play on our phones, which was sort of embarrassing. But over time, I developed a real passion for the activity. And by my senior year, it was one of my favorite aspects of my high school experience.
That's wonderful, Ms. Becker. And from your own perspective, what did your relationship look like with your coach?
Mr. Brackman and I had a lot of conflict. We got into a lot of arguments. We didn't get along all the time.
Despite all those arguments, were you proud of your accomplishments on the team?
Yeah, I thought we were a great team, and I thought that I was an excellent participant on that team.
Were you ever demoted to the B team, though?
Yeah, so unfortunately, shortly before the regional competition in my senior year, Brackman and I got into kind of an argument over how I had prepared for practice, which resulted in him ultimately demoting me to the B team.
Did you ever regain your position on the A team?
Yeah, so my best friend Taylor Perkins chose to quit the A team in order to, benefit the team overall because he thought that it would do better if I was on it, which was very gracious of him.
Under Rule 602, need for personal knowledge, this witness cannot speculate as to the mental state and motivations of Mr. Perkins for quitting the team.
Damiana, response.
Your Honor, I don't believe this is speculation, as first of all, Avery Becker and Taylor Perkins are best friends. They had a conversation over this, and I do believe that Taylor Perkins told Ms. Becker that.
Response, Your Honor?
Ms. Proctor, go ahead.
Then I change my objection to hearsay. It is an out-of-court statement being offered for the truth of the matter asserted.
So to cut through the fat a little bit here, Ms. Damiana, assuming that I overrule the objection let's take it this way. Let's say that I want you to lay a little bit of foundation to set up this answer. So I sustain this first objection, you get through the foundation, and then you're left with the statement. Why would it not be hearsay?
Your Honor, it would not be hearsay, as what Taylor Perkins said is not offered for the truth of the matter, but just to illustrate Avery Becker, how it affected Avery Becker and the regional tournament.
Ms. Proctor, I see you've unmuted. I assume you have a response to that. Go ahead.
Yes, Your Honor. I believe that, or the statement that Taylor Perkins quit the team for the good of the team is in fact being offered for the truth of the matter asserted. The defense is trying to show that the motivations of Mr. Perkins, which ultimately is being offered for the truth of the matter asserted.
I'm going to allow this. I'm going to overrule those objections. Ms. Damiana, just to cut through a little bit of the time, since we've spent some on this objection, you can just move right into the statement, and let's forbear ourselves the hearsay objection if we could, please. Go ahead, Ms. Damiana.
Ms. Becker, would you like me to restate the question?
Oh, I believe my answer was simply that Taylor quit the team in order to help me regain my position.
All right, perfect. And were you proud of how you performed at the regional tournament?
Yeah, I thought we did very well. In fact, we actually ended up winning the regional tournament, and I won some awards, and I was very proud of that.
How were you received by Mr. Brackman and the rest of your team afterwards?
Well, unfortunately, Mr. Brackman and I got into an argument after the regional competition at the practice. He didn't agree that I deserved the awards that I had gotten.
Objection, Your Honor. This is speculation again under Rule 602, need for personal knowledge, as she cannot speak to the mental state of Coach Brackman.
Counsel, response.
Your Honor, I don't believe that Ms. Becker is speaking to the mental state of Mr. Brackman, just simply stating that he didn't agree with her, which is something that I believe they had a conversation about.
So I would agree with Ms. Proctor, at least in the sense that I don't believe you've laid the foundation for how Ms. Becker would know that information. If you want to delve into how she would know that information, you're welcome to, and then we can deal with an objection from there if there is one as to hearsay, but I think we need some more foundation before we delve into your client testifying as to what the coach's belief was. Go ahead.
Thank you, Your Honor. Now, Ms. Becker, did Mr. Brackman and you have a brief argument after the regional tournament?
Yes, we did.
And what was the nature of that argument?
We discussed my performance at the regional competition, and it was my perception, from what he said to me, that he did not, or he indicated that I had not prepared well enough, and that he, didn't think that I should be, or should have received the awards that I got.
And how did that affect you?
I was pretty upset about that. I had been proud of how our team and how myself had performed at regionals, and I disagreed with him.
What did you do in response to that disagreement?
Well, I made the extremely unfortunate and irresponsible decision to storm out of practice and write worst attorney award on his car. I believed at the time that I was writing with a dry erase marker, which my actions are still completely inexcusable. But yeah, that is what I did, unfortunately.
And from your own perspective, how did Mr. Brackman respond to this incident?
Mr. Brackman was reasonably angry, given that I had vandalized his car and he kicked me off the mock trial team, which was, it really upset me.
And could you elaborate on how you felt after the incident?
I felt angry. It was not a moment of grace on my part, and I was angry at being kicked off the team for what at the time felt like kind of very little reason at all.
Did you apologize for that incident ever?
Yeah, so I pretty quickly realized that what I had done was wrong, and decided that I needed to apologize. So I went to Brackman's office the next day in attempt to do so.
How were you received at his office?
His secretary wouldn't let me in. I don't know why, but she wouldn't. And so I chose to send a text message, basically saying what I would have said to Brackman in person, which was that I was sorry and that I would pay for the damages to his vehicle.
Did Mr. Brackman ever respond to this text message?
No, unfortunately, I believe he was killed before he responded to it, so I never received a response.
Now, Ms. Becker, at the time of Coach Brackman's death, did you still feel guilty about his car?
I still feel guilty about what I did to Brackman's car. It was extremely irresponsible and terrible decision. So yeah, I felt even guiltier at that point.
Now, shifting focus, what happened on March 5th, the day before Mr. Brackman's murder?
Well, it was a school day, and then Taylor Perkins and I hung out at the mall for a while, and the Fry Shack in the evening.
Did you lose your phone that day?
Yeah, I did.
Were you ever able to retrieve your phone?
So after I tried to find it the next morning, I realized that it was nowhere in none of its normal hiding places, and so Taylor and I went to look for it, and we were unfortunately unable to find it.
Are you aware of any calls made to that phone on that day?
Yeah, so the way that Taylor and I were looking for the phone was to call it a bunch of times to see if it would make a noise while we were at the mall. So we called it a whole bunch of times from Taylor's phone, but we never found it.
And you spent the entire day looking for your phone?
Yeah, I mean, it was lost and we were trying to drive around and find it.
Was Taylor with you that whole time?
Yeah, I mean, we needed to look together. 2 pairs of eyes are better than 1, I suppose.
And did you ever intend to go near Mr. Brackman's house while you were looking for that phone?
I mean, aside from the fact that we didn't even know where Mr. Brackman's house was, it wouldn't make any sense for us to go over there. I mean, I didn't lose my phone at Mr. Brackman's house.
Right. And switching topics, would you consider yourself close to Alex Cifuentes?
Not really. Alex and I knew each other through mock trial, but I wouldn't call us close or really friends.
And would you have sent any text to Alex Cifuentes possibly asking for help?
Alex Cifuentes is kind of the last person I'd ask for help on anything. We just don't know each other that well.
Would you have sent these text messages to Alex Cifuentes in what has been previously marked as Exhibit 14?
Absolutely not. I don't really know what these are, and certainly not something I would have sent to Alex Cifuentes.
Now, Ms. Becker, is it true that you plan to trash Mr. Brackman's house?
No, aside from that being extremely irresponsible, it wouldn't have served my goals since I was trying to get back in the mock trial team at that point. Besides, Brackman's house was not a concern of mine.
Did you plan any other retaliatory acts against Mr. Brackman?
Of course not. Again, that would have been horrible. And Brackman and I had conflict, but our relationship was never violent.
And Ms. Becker, I hate to ask this, but were you responsible then for the murder of Mackenzie Brackman on March 6th of 2020?
Absolutely not. And I'm so sorry it ever happened to him. It's really horrible.
Thank you, Ms. Becker. Your Honor, I have no further questions at this time.
Thank you, Ms. Damiana. For the people, Ms. Proctor, you may inquire on cross-examination.
Yes, Your Honor. Good morning, Ms. Becker. Good morning.
Good morning.
My name is Madeline Proctor. Let's start with the mock trial team. You thought you were the best attorney on the entire team.
I think I was, yes.
But Coach Brackman always criticized you.
We had a lot of disagreements.
Let's talk about Coach Brackman. You two would get into arguments at almost every practice.
Yeah.
And after one of those arguments, you were even demoted to the B team.
Yeah, I was, unfortunately.
That's a team you call a team full of losers.
I did think that at the time.
Miss Becker, is it your testimony here today that you do not still think the B team is a team full of losers?
I definitely thought that the B team was a team full of losers. I suppose I would have said that.
Miss Becker, that's a yes?
That would be a yes.
So you tried everything you possibly could to get back onto the A team.
I did try and come up with some different methods for getting back on the A team, yes.
But none of it worked at first.
Not at first.
Until your best friend in the entire world, Taylor Perkins, quit the team.
I mean, Taylor told me it was for the good of the team.
Becker, I'm not asking about the motivations of Mr. Perkins. I'm just asking that Taylor Perkins quit the team and then you were reinstated. Yes?
Graciously, he definitely did.
That's the same Taylor Perkins who you claim to be with on March 6th?
Yeah, I only know one Taylor Perkins.
Right, and that is the only person who you claim to be with on March 6th.
I mean, that was the only person I was with the whole day. There were other people around us. We were at the mall.
Ms. Becker, you and Mr. Perkins are the only people who will testify to this jury that you two were together on March 6th.
I believe that we're the only people who will testify to experiencing that.
So yes.
Yeah.
All right, Miss Becker. So let's talk about what happened once you got back onto the team. You won some awards at the regional tournament.
Yes, we did. And I did as well.
And Coach Brackman told you you did not deserve those awards.
Yeah, he did.
Objection, Your Honor. I apologize. I had an objection to the question as hearsay.
Response, Your Honor?
You may, Ms. Proctor.
The fact that Ms. Becker did not deserve those awards is not being offered for the truth of the matter asserted. It is simply to go to the effect it had on Ms. Becker in making her angry and leaving the practice.
For that purpose, I'm going to overrule the objection. You can proceed, counsel.
So, Ms. Becker, Coach Brackman told you you did not deserve those awards.
Yeah, he did tell me that.
And then you got mad.
Yes, I was quite upset.
Upset, but also mad.
I would qualify that as part of upset, but yes.
So you stormed out of practice.
Yeah, unfortunately I did that.
And when you got to the parking lot, you saw his Porsche.
I did see his Porsche.
The same Porsche you knew he loved.
I did know that he loved his car.
And you took a permanent marker to his car and wrote Worst Attorney Award.
Inexcusably, that is something that I did.
Right, and you said on direct, I wrote something down because I didn't want to forget it. You were kicked off the team for very little reason at all.
I felt that at the time, certainly. I do not feel
Right,
that
Ms.
now.
Becker,
I feel that he
my
was
question,
completely
Ms. Becker,
reasonable. And
Ms. Becker, my question is not whether or not you still agree with that statement, simply that you said on direct, I was kicked off the team for what seems like very little reason at all. Yes?
what I said on direct was that was how I felt at the time.
Ms. Becker, you felt like you had very little reason at all. Yes?
I certainly felt that way at the time. That's the truth.
Right. So then when Coach Brockman came outside, he was mad.
Reasonably so.
And he kicked you off the team for good.
Yes, he did.
Now you were even madder.
Unfortunately, I was.
And when you got home, you did not tell your mother what really happened that night.
In a lie that I now regret, I told her that he kicked me off the team
Ms.
for
Becker.
no good reason.
Ms. Becker, no good reason, right?
In a lie that I now regret, yes.
And you blamed it on someone else.
I did not tell her what I had done.
Ms. Becker, that was not my question. My question was that you blamed it on someone else. Sounds like your answer is yes.
Yeah.
You also told your mother, I will get back at Coach Brackman if it's the last thing I do.
I unfortunately.
Objection, Your Honor.
Go ahead, counsel.
I believe that this is improper character evidence, and the question is trying to prove that a trait is being used to, I apologize, Your Honor. I believe that this question is asking to prove a trait where Ms. Becker would have acted in accordance with this in another situation.
Yes, ma'am. Go ahead.
This is not a trait trying to be proven. This is a threat that Miss Becker made on one night. And I'm simply trying to find out whether or not she said those words.
Ms. Damiano, would you like a response to
that? Your Honor, I stand by my objection that while a trait may not be explicitly said, I believe that one is being alluded to.
Right, well, here's what I'm going to do, counsel. I'm going to allow the question, so I'm going to overrule the objection. I am going to, in an abstract universe, give the jury a limiting instruction. I think if we're going to be using this evidence, what it really relates to is a question of motive as opposed to conformity of behavior. And so we'll make sure that we give the jury an advisement not to construe prior behavior as an indicator of future behavior. They are welcome to use the context as motive if they would like. Proctor, you may proceed.
Yes, Your Honor. Miss Becker, on that night, you said, I will get back at Coach Brackman if it's the last thing I do, right?
Unfortunately, I did say that.
The more you thought about it, the more you knew exactly what you had to do, right?
Apologize.
Ms. Becker, is it your testimony here today that the more you thought about it, you knew exactly what you had to do, which is apologize?
I believe that's what I said in my witness statement I prepared for court today. It's possible that we could have interpreted that differently, but I do believe that what I believed that evening was...
Ms. Becker, are you saying that what you meant by the more you thought about it, the more you knew exactly what you had to do was apologize?
Yes, that is my testimony.
And you provided a statement for today's case.
I did provide a witness statement for today's case.
And you signed that statement.
I did sign that statement.
Swearing that it was complete?
Yes, I did.
And accurate?
Yes.
And truthful?
Yes, I did.
And nowhere in that statement do you say in the same sentence, the more you knew you had to do, or in that statement, you only say, the more I thought about it, the more I knew exactly what I had to do, right?
Counsel, at the risk of testifying to something that is hearsay, I would argue that the thing that I said in my statement based on context.
Miss Becker, Miss Becker, I'm not asking you to testify to hearsay or to try to extrapolate on that. All I'm asking you to say is whether or not your statement only says, the more I thought about it.
Objection, Your Honor.
Counsel, go ahead.
I believe that my witness should be allowed to defend themselves, as I do believe that what they were saying was important for the jury.
Response, Your Honor?
Go ahead, Ms. Proctor.
I believe if Ms. Becker would like to explain her statement and provide further context from her perspective, besides the facts which were included in her statement, she has time for that on redirect.
I would agree that is appropriate for redirect. I would say, though, that I think the line of questioning is getting a little bit beyond the scope here. You've done an impeachment here with the witness as to what the testimony was in the witness statement versus what it was on the stand now. That's been done effectively, so I think we can move it along from there, Counsel.
Yes, Your Honor, I'll move on. And when you tried to apologize, you were turned away.
His secretary wouldn't let me in. I don't know why.
Now you weren't just angry, you were devastated.
I was extremely sad. Yes.
Yes. Because mock trial means a lot to you, doesn't it?
Mock trial was an activity I really enjoyed.
Thank you, Ms. Becker. Your Honor, I have no further questions.
Thank you, Ms. Proctor. Ms. Damiana, I assume there is some material you'd like to cover in a redirect.
Yes, there is, Your Honor. Ms. Becker, would you call your relationship with Mackenzie Brackman aggressive?
No.
And after the incident involving his car, did you apologize?
Certainly. And I believe that I made it clear that I needed to apologize, or that I desired to apologize that evening.
And how long did it take you to realize that you needed to apologize?
Several hours after the incident.
And did you still feel guilty about this incident on March 6th?
I mean, I still feel guilty about what I did to Brackman's car.
Objection, Your Honor. Asked and answered. This is no different from the question that was asked on direct examination, and the witness is giving the exact same answer.
Ms. Damiana?
Your Honor, I believe that this is being used for clarification.
I'm inclined to agree with Ms. Proctor. I think that was virtually the exact same question and answer. I appreciate the purpose for it, Counsel, but the jury does have that information. You can move on.
All right, thank you, Your Honor. And Ms. Becker, would you have therefore wanted to further strain that relationship by carrying out any other aggressive behavior towards Mr. Brackman?
No, Mr. Brackman and I had conflict, but I never had a desire for tremendous revenge, on after I was kicked off the team. I'm pretty quickly felt bad about what I had done.
Thank you, Ms. Becker. Your Honor, I have no further questions for this witness.
Ms. Proctor, anything that needs any last bit of follow-up from your side of things?
No, Your Honor.
All right, Ms. Damiana, may we excuse your client can't be excused. She's got to sit next to you at the table, but we can let her off the witness stand, I assume. Is that correct?
Yes, Your Honor.
All right, excellent. Does the defense have any additional witnesses they'd like to call at this time?
Yes, Your Honor. The defense calls Taylor Perkins to the stand.
All right, and Taylor Perkins, if you would please, let's have you raise your right hand. I'm going to swear you in. Mr. Perkins, do you swear under the penalty of perjury that the testimony you are about to give is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, the witness is so sworn. Mr. McKinney, you may proceed with your line of inquiry, sir.
Thank you, Your Honor. Mr. Perkins, glad you're here. Please state your name and spell the last for the record.
Hi, my name's Taylor Perkins, and my last name is spelled Perkins.
That's wonderful, Mr. Perkins. How old are you?
I'm 19 years old right now.
And where did you go to high school?
Last year, I graduated from Colorado High School, or CHS, as everybody just calls it.
And what is your relationship with Avery Becker?
Oh, Avery and I are best friends. I mean, you could even call us besties. We're close.
And how long has this friendship lasted?
For pretty much as long as I can even remember. Definitely for a pretty long time.
And were you in mock trial with Avery?
Yeah. Funnily enough, it was actually Avery that recommended I even join mock trial in the first place. Joined freshman year and stuck with it through senior year.
And besides mock trial, did you hang out with Avery inside and outside of school?
Oh, all the time. We'd be carpooling to and from school. We shared a lot of our classes together. I mean, even the boring ones too. And after mock trial, we'd even hang out together after school.
And based on your perception, how was Avery as a member of mock trial?
Avery was an incredible attorney. I mean, you really just had to see it to believe it. But as a member, she could be underprepared at times.
And in your perception during practice, how did Coach Brackman react to this unpreparedness?
Well, every time Brackman would get upset with her, he'd always be yelling at her and telling her what she should have done better.
And was Avery ever demoted for this kind of behavior?
Unfortunately, Avery was. One practice when she showed up the most unprepared I think I've ever seen her. I mean, it was almost a train wreck. He decided to demote her to B team.
And what did you do after this happened?
Well, I had to think about it for some time. I mean, even though it was an easy decision, I still took 3 weeks to consider what I wanted to do. And I stepped down from the B team for Avery and the team. Or stepped down to B team, rather. I apologize.
And unpreparedness seems to be one concern for Coach Brackman, but how was Avery and Brackman's as a relationship as a whole from your point of view?
From what I could tell, the relationship was never positive. They didn't usually get along.
And did this strenuous relationship ever result in any serious actions?
Yes. This actually resulted in what I've now dubbed as the car incident.
And after this car incident, were you with Avery after this car incident?
Yeah, I actually was with Avery right afterwards.
And what was, in your view, Avery's reaction to this conflict?
I mean, she was visibly upset, but she knew she needed to apologize. She was distressed by it.
And did you two do anything the night before Coach Brackman's murder, March 5th?
Yeah, actually. We decided that I wanted to bring her out of her slumps. She was pretty down in the dumps because of the mock trial situation. And we decided to hang out at my house. So we even went to the Fry Shack later.
And did anyone else show up at the Fry Shack?
No one was at the Fry Shack necessarily at first, but after we'd gotten our orders, some other members of the mock trial team did trickle in.
And what events occurred with those other mock trialers or mockers?
Well, almost everybody seemed super apologetic, but except for Alex Cifuentes. From what I could tell, Alex Cifuentes was just being totally insincere and passive aggressive toward Avery.
And moving on to the day of the murder, March 6th, what were you doing?
Well, I started that morning like any other morning. I was getting ready for school, and I texted Avery because we tended to carpool a lot, but Avery just wasn't responding.
And what did you conclude from this?
Well, nothing at first, but Avery did show up at my house later because we did carpool, and we decided then that she had lost her phone the previous night.
And where was the last place you saw the phone?
Well, funnily enough, remember when I said that Alex was being totally insincere? It caused Avery to storm off, and she left her phone on the table in front of Alex Cifuentes.
And where did you look for the phone?
Well, we skipped class just to go look around at the places we'd been the previous night. We went to the mall and even to the Fry Shack.
And how did you look for the phone?
Well, We looked all over for it, just retracing our steps from the previous day, but eventually I started calling it to see if we could hear the ringtone of the phone.
And was calling the only way to find the phone at the time?
Unfortunately, it wasn't, but it was the only way that Avery and I had thought about. Apparently, you can use this iCloud website to track an iPhone, but I have an Android, and neither of us even thought to use it.
And so on the day of Brackman's murder, March 6th, were you with Avery all day?
Yes, the entire day.
And did Avery ever leave for any period of time?
No, she was my ride. If she left me, I would have been stranded at the mall.
You went to the mall, the Fry Shack, but did you ever go to Coach Brackman's house?
No, we did not.
Did you have a reason to go to Coach Brackman's house?
No, we were looking for the phone, and we didn't even know where Brackman's house was.
So Avery was with you all day, and you never went to Brackman's house. So did Avery kill Coach Brackman?
I can say with 100% certainty that Avery did not kill Coach Brackman.
Thank you, Your Honor. Thank you, Mr. Perkins. I have no further questions.
For the people, cross-examination. Ms. Sayers, you can proceed when you're ready.
Yes, Your Honor. Good morning, Mr. Perkins.
Good morning.
My name is Feliciana Sayers. Let's start with your relationship with Coach Brackman. You thought Coach Brackman was a mediocre coach.
I mean, you know the phrase, those who can't, don't. They just coach instead.
So you thought he was a mediocre coach.
I thought he was a mediocre coach.
You thought he made bad choices for the team.
I did.
From what you saw, he thought Ms. Becker put little effort into mock trial.
I think that's what Brackman thought, yeah.
Objection, speculation. Is that question, sorry, I didn't unmute properly. That objection called for speculation. As much as it's perception, it's still a testimony about the inner thoughts of Coach Brackman.
Counsel, response.
Your Honor, this witness is testifying to his rational perception. Additionally, this is cross-examination. If this witness does not know the answer, he can say so.
I'll overrule the objection with that advisement to the witness, I suppose. Go ahead, Ms. Sayers.
Ms. Becker would often show up late and unprepared to practice.
That was one of her habits, but it didn't ever inhibit her mock trial skills.
From what you saw, Coach Brackman did not like Ms. Becker.
He was never
speculation.
Ms. Sayers?
Your Honor, I am asking Mr. Perkins what he saw and what he interpreted from what he saw in these mock trial practices. Again, this is also cross-examination, so if he doesn't know, he can say so.
I'm going to overrule that objection. I think that's fair testimony just in terms of what his observations were. I will say, counsel, to the extent that you are willing or able to lay a little bit of foundation, that will likely spare you from some of these objections as we continue to move through the testimony. You can proceed.
Mr. Perkins, from what you saw, Coach Brackman did not like Ms. Becker, did he?
He was never a fan of the way she practiced as an attorney. They never really got along, though.
Now let's talk about what happened a month before the regional tournament. Ms. Becker came to practice most unprepared you had ever seen.
It was pretty bad, yeah. She was really unprepared that day.
She was obviously making things up on the fly.
I mean, yeah, and she even strayed a little bit from her closing argument, but that's what happened.
You even said on direct, it was a train wreck.
It was pretty bad.
Coach Brackman got so heated about this, he demoted her to the B team.
Yes, he did.
You thought Ms. Becker deserved to be on the A team.
I mean, she was an incredible attorney. I mean, she typically performed flawlessly. I think she deserved to be on the A team.
So you decided to quit the mock trial team in support of your best friend.
In support of my best friend and the team's best interests, yeah.
Yeah, Mr. Perkins, you did not quit the team the day after Ms. Becker was demoted.
No, I took 3 weeks to mule it over and think about it.
That's right, Mr. Perkins. You took 3 weeks, a week before the regional tournament, to quit the mock trial team.
Yeah, that's exactly what happened.
Leaving Coach Brackman no choice but to put Ms. Becker back on the A team.
I guess that's what happened, yeah.
Mr. Perkins, you quit the mock trial team a week before the regional tournament to leave Coach Brackman no choice but to put Ms. Becker back on the A team.
I mean, I truly did believe that Miss Becker was going to lead them to winning state. I mean, that's what, or I guess regionals at that point. Yeah.
Now, let's talk about what happened at the practice after the regional tournament. After a heated practice, Miss Becker left and Sharpied Worst Attorney Award on the hood of Coach Brackman's Porsche.
Well, I wasn't actually there, but that's what Avery told me that she did. Yeah.
In an effort to get back on the mock trial team, Miss Becker texted everyone on the team for help.
I mean, yeah, she texted everyone. I mean, even Alex Cifuentes, which I didn't think she would do.
Yes, Mr. Perkins, even Alex Cifuentes.
Yeah.
Now let's talk about March 5th. Miss Becker attempted to show up at mock trial practice after school.
Yeah, she went to go apologize to Miss Brackman, make everything right again.
She was then told to leave.
Yeah, she was.
So she went to your house.
I mean, yeah, we decided to hang out at my house, try to lift her spirits back up again.
And the two of you played games on your phones.
Oh, we always play games on our phones, but yeah, we were trying to hang out and just talk over stuff again.
Yes, Mr. Perkins. And later that evening, the two of you went and hung out at the Fry Shack.
Yeah, we did.
Even later that evening, the two of you went to the mall.
Yep.
Mr. Perkins, as a member of the mock trial team, you understand the importance of keeping a clear record. Please answer yes or another appropriate response to my question instead of yeah or yep or any other guttural noises.
Okay.
The next morning, Ms. Becker picked you up for school.
Yeah, that's exactly what happened.
It wasn't until you pointed it out that Ms. Becker realized her phone was missing.
Well, that was at the point that we realized that it was missing, but yeah, that's what happened.
Is that a yes, Mr. Perkins?
Yeah, that's when we realized that the phone was missing.
So the two of you decided to spend the day looking for Ms. Becker's phone.
We retraced her steps, and I even tried calling it. We were trying to find her phone.
According to you, Mr. Perkins, the two of you spent the entire day looking at the mall.
Yeah, and then afterwards, we even went to the Fry Shack later to see if we could catch it with the evening shift workers.
Yes, Mr. Perkins. Later that evening, you went to the Fry Shack.
Yeah.
Yeah, Mr. Perkins, according to you, the last place you remember seeing Ms. Becker's phone was at the Fry Shack the night before.
Yes, it was.
Now, Mr. Perkins, you and Ms. Becker are the only people testifying today that the two of you spent the entire day together.
Yes, we'll be the only people testifying to that, yes.
Thank you. Your Honor, I have no further questions.
All right. For the defense, any redirect?
Yes, Your Honor, briefly. Mr. Perkins, when Avery was demoted, when you stepped down, what was the intention of that?
I mean, I guess it could have been to help Avery, but it was also to help the team. I really didn't think they had a chance of winning without Avery on it.
And moving on to the day when you looked for your phone, did you remember where the phone was at the beginning of the day?
No, I didn't.
You saw the phone, sorry.
Sorry, I was a little bit confused there, but I only remembered where it was after we were looking for it.
Thank you, Your Honor. No further questions.
Ms. Sayers, anything you'd like to follow up on there?
No, Your Honor.
Mr. McKinney, with seeing nothing further for this witness, can we excuse them from the stand?
Yes, Your Honor.
Thank you, Mr. Perkins, for your testimony. Your excuse, sir. Do the defense have any additional witnesses they would like to call at this time?
Yes, Your Honor. The defense would like to call Professor Blake Van Owen to the stand.
And Professor Van Owen, thank you for joining us this afternoon. Sir, if you would please, I'm going to have you raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you are about to give is the truth, the whole truth, and nothing but the truth?
I do.
All right. Thank you, sir. Mr. Littlewood, you may proceed with your line of inquiry, sir.
Thank you, Your Honor. Could you please state your full name and spell the last for the record?
Certainly. My name is Blake Van Owen, last name spelled Vanowen.
And would you tell the jury your connection to this case?
Yes, I've been consulted by the defense as a private investigator to find certain aspects of the scene of the crime that were not previously found.
How did your career in law enforcement begin?
I worked as a police officer for the Aurora Police Department briefly until I moved on to a wide variety of other professions.
Why did you decide to leave the Aurora Police Department?
There was a certain incident in which a detainee of mine was injured, and after reaching a settlement, I felt guilty and thought that there were intrinsic flaws within the police department and sought occupation elsewhere.
Were you fully cleared of any wrongdoing from that incident?
I was, yes.
What did you do after leaving the police department?
I taught community courses at a community college. I also went on to get my master's degree on Ashford University online, which led me to teach courses at CU Denver, earning me the title of Professor Van Owen.
What is your master's degree in?
Criminology.
And do you frequently appear as a witness in court?
I do, yes.
When conducting investigations as part of your job, do you frequently deal with cases that use cell tower analysis?
I do, yes.
Do you frequently review the work of crime scene reconstructionists?
Frequently.
And when you appear in court, or my apologies, in how many states have you been accepted as an expert in district courts?
3 states, those of Colorado, Kansas, and Arizona.
In how many states have you been accepted as an expert in state courts?
4, those of Colorado, New Mexico, Nebraska, and Wyoming.
How many times have you been accepted as an expert in crime scene reconstruction?
8 times.
How many times in cell tower analysis?
5 times.
General police investigation tactics?
12 times.
And how many total cases have you consulted in?
I'd say over 100.
Your Honor, I would like to qualify Professor Van Owen as an expert in crime scene reconstruction, cell tower analysis, and general police investigation tactics on the grounds of his extensive education and experience as an expert in these fields under Rule 702.
Response from the people.
Your Honor, voir dire, please.
You may.
Good morning, Professor Van Owen.
Good morning.
You said on direct examination that you received a master's degree in criminology, correct?
From Ashford University online, criminal practices, yes.
Criminal practices. Is it your testimony today that that is the degree you received?
Are you requesting specificity in my degree?
I'm asking you, is it your testimony today that you received a degree from Ashford University, a master's degree in criminology?
Yes.
You prepared a statement for today's case.
I did, yes.
You signed that statement.
I did, yes.
And by signing that statement, you promised it was complete.
May I ask a brief question? Are you distinguishing?
Unfortunately, Mr. Van Owen, as the witness, you are not entitled to ask a question, sir. You are entitled to answer them. Mr. Powell, you can proceed.
Yes, I did prepare a statement.
And that statement, by signing it, it was complete.
Yes.
And it was accurate.
Yes.
And by signing that statement, you promised it was truthful.
I did, yes.
And in that statement, you say you received a degree from Ashford University in criminal justice, correct?
Yes, I'm sorry for mixing those two up, yes.
Your Honor, I object on the grounds that that Professor Van Owen doesn't even know the degree he received.
Your Honor, if I may respond.
I'll spare you, Mr. Littlewood. I think that's what we in the law would call a distinction without a difference. May matter a lot to people with a diploma. It does not matter a lot to the court in terms of the tender. So I'm going to accept the witness's tender as to crime scene reconstruction, cell tower analysis, and general investigative techniques of the police in investigating crimes. Mr. Littlewood, you can proceed.
Thank you, Your Honor. Now, in your work at the case at hand, what police evidence did you review informing your opinion of the case?
I consulted both the work done by Detective Markowitz and that done by Mr. Kuzak.
Can I ask you now about some of your specific issues with Kuzak's conclusions? What is Kuzak's theory of how the confrontation occurred between the victim and the intruder in the victim's home?
He generally believes that there was an intruder who broke into the home and through a scuffle with Mr. Brackman, killed him by stabbing him with a knife.
What evidence did Kuzak use to back up this theory?
He cites the scuff marks located near the door, as well as the specific angle of the knife and the type of knife found.
Do you take any issue with the scuff marks?
I do, yes. As was alluded to in this trial, I take issue with the time. There's no way of knowing when these scuff marks were made or that they were made through the scuffle.
And do you take any issue with his conclusions based off the angle of the knife?
I do, yes. While in my theory, it is unusual that a knife would be held at the angle that I report it to, I find that my conclusion of the scuffle, which is not a scuffle, sorry, the murder is much more likely than the fight that Mr. Cusack purports.
Now, moving on, are you aware that Brackman had Ring doorbells set up at his residence?
I am aware of this, yes.
Did the police make any investigation to determine if Brackman had push notifications on for these Ring doorbells?
They did not, no.
Would this have been within their power?
It certainly would have, yes.
Now let's move on to your evaluation of Detective Markowitz's investigation. Were you present today in the courtroom during the testimony of Taylor Perkins?
I was, yes.
Do you recall Perkins' statement that during the time of the murder, Perkins and Avery were searching for Avery's lost phone at the mall?
I did hear that, yes.
Were you aware of this fact prior to the trial today?
I was.
Now, since Avery did not have their phone during the time of the murder, even if the cell tower data indicated that their phone was near the victim's house, would that by any means mean that Avery was near the victim's house?
Not inherently, no. Just because Avery's phone was in the general vicinity does not equate to Avery being there herself.
Now, did the detectives look at the cell tower data for Taylor Perkins' phone?
Markowitz gathered, but did not really examine it in depth, no.
Would it have been within their power to access this data?
It certainly would have, yes.
Did you view the cell tower data for Taylor Perkins' phone?
I did take it, yes, and examined it.
What did this data indicate?
It corroborated the theory, the testimony provided by Mr. Perkins that the two were in fact looking for the missing phone at the mall.
Now, in reviewing the evidence for this case, did you view the screenshots of the text messages shown in Exhibit 14?
I did, yes.
Did you take any issue with these screenshots?
Yes, I do. I take issue with the fact that there are no timestamps. We do not necessarily know that that number is Avery. And just in general, the authenticity remains a dilemma for me since these documents could certainly be doctored.
Would it have been within the power of the police to search Cifuentes' phone to verify the validity of these messages?
Absolutely. In general police work, they have access, and the ease of access to Alex's phone is certainly available, and Detective Markowitz chose not to make that investigation.
And during your investigation, did you develop any suspects for this crime that you feel the police overlooked?
I did. One, Blair Rollins.
What was Blair Rollins' relation to Brackman?
Blair Rollins was the son of a former client, Jonathan Rollins.
And in Brackman's work with Jonathan Rollins, was that a criminal case? What was the nature of that work?
Yes, Jonathan Rollins was a client who was convicted as a result of Mr. Brackman not effectively working as his defense lawyer.
What was the sentence given to Jonathan Rollins?
It was a life sentence.
Is Blair Rollins roughly the same build as Avery Becker?
Yes.
Where's Blair Rollins now?
I do not know.
Have you tried to find Blair Rollins?
I have, yes, but to no avail.
Did the police try to find Blair Rollins?
While briefly alluding to Blair as a suspect early on, there was not a legitimate investigation into Blair's whereabouts.
Thank you. No further questions at this time.
Thank you.
Mr. Powell, the witness is yours. You may inquire.
Yes, Your Honor. Good morning, Professor Van Owen. My name is Chalmers Powell. Let's talk about the text messages. You believe Alex Cifuentes faked these messages?
I'd just say that there's a possibility for doctoring that the police could have easily avoided.
Right, so there's a possibility that they were doctored.
Yes.
But nothing on the screenshots actually indicates that they were doctored. Isn't that true?
While there's no inherent evidence that they were doctored, there's also no inherent evidence that they were fully legitimate.
Let's talk about your investigation of Blair Rollins. You believe Blair Rollins had a motive?
Yes, a very legitimate motive that should have been investigated.
You believe she had a motive because Jonathan Rollins yelled something to Mr. Brackman?
Yes, in a failure to get Jonathan Rollins free of the sentence, Jonathan Rollins promised revenge, if you will.
Really? Jonathan Rollins says Brackman is going to die.
Objection, Your Honor. Hearsay.
May I respond?
You may.
Your Honor, this is an exception to hearsay pursuant to Rule 8032 in an excited utterance. Jonathan Rollins had just been sentenced to life in prison and made this statement after that startling event.
Your Honor, if I may respond.
Go ahead.
I don't believe that the proper foundation was laid to qualify this as an excited utterance prior to the question being asked.
I agree with all of that, actually. I think that if you want to lay the foundation, Mr. Powell, you are welcome to, and then that answer certainly comes in at that juncture. But for now, I'll sustain the objection.
Thank you, Your Honor.
Professor Van Owen, Jonathan Rollins yelled something after he was sentenced to life in prison, correct?
That is correct, yes.
He yelled, "Brackman is going to die."
Yes,
You've heard Exhibit 22, right?
I have.
Professor Van Owen and Mr. Littlewood, please direct your please direct your attention to Exhibit 22. Exhibit 22 is an accurate recording of that statement Jonathan Rollins yelled. Correct?
Yes, I don't have it on me, but yes, it is.
Objection, Your Honor. Pursuant to the rules of competition 7.4, all witnesses shall have all case materials available and in their possession during testimony.
Your Honor, as this is a video recording, it would be somewhat almost improper for the witness to review the exhibit prior to answering the question.
Let me cut this one down the middle. Professor Van Owen, do you have the ability to access this document on your side of things?
I do. I opted not to, as it was an audio file, which would then play to the entirety of thus me entering into evidence.
Understood. Mr. Powell, appreciating the position, your witness does have that exhibit ready. If you would like for him to review it, you can guide him to it, ask him to open it. There is the technological limitation. I don't view that as a violation of the rules. The witness has access to the material. Again, I appreciate where you're coming from, but if you want to get into that material, you can ask him to access that exhibit. We'll get into it.
So, Professor Van Owen, Exhibit 22 is a fair and accurate copy of that recording.
Yes.
Your Honor, the people request Exhibit 22 to be admitted to evidence for its accuracy has been shown and its authenticity has been stipulated to.
Mr. Littlewood, response.
No objection, Your Honor.
Exhibit 22 is admitted. Proceed.
Your Honor, permission for Ms. Sayers to play Exhibit 22?
Certainly.
I'll get you back, Brackman, if it's the last thing I do.
Thank you, Ms. Sayers. Professor Van Owen, Jonathan Rollins doesn't say Brackman is going to die, does he?
No, he does not.
Right. And so you spoke to Blair Rollins about this statement, didn't you?
I did not have I did not find Miss Rollins, no.
And you didn't speak with Jonathan Rollins about this?
He was in prison and thus was not seen as a suspect, so no.
So the only evidence of a motive you have of Blair Rollins is that her father said something to Mr. Brackman, correct?
Yes, and just the general fact that her father was prosecuted as a result of a failure upon Mr. Brackman's behalf.
And Professor Van Owen, let's talk about the knives. You believe that the knife was brought into the home?
I think that's a legitimate possibility, yes.
But you think that's what happened?
Yes, in lieu of what was suggested by Mr. Kuzak, yes.
And you've seen the ring videos?
I have, yes.
You saw the intruder in those videos?
I did see, yes.
You didn't see the intruder carrying a knife, did you?
No, that does not preclude them from having a knife on them, though.
Well, the knife was 12 inches long, wasn't it?
Correct.
So you want us to believe that she put a 7.5-inch blade in her pocket?
It's a possibility. I'm not going to testify to whether or not what's in her pocket since it's not visible in the camera.
Exactly. Thank you, Professor. Your Honor, I have no further questions at this time.
Mr. Littlewood, anything we need to follow up on there, sir?
Yes, Your Honor.
You may proceed.
Professor Van Owen, whose job would it have been to investigate Blair Rollins at the police department?
Detective Markowitz in the police department.
Whose job would it have been to interview Blair Rollins?
Detective Markowitz.
Whose job would it have been to find Blair Rollins?
Detective Markowitz in the police department.
Whose job would it have been to interview Jonathan Rollins?
Ideally, Detective Markowitz.
And who was in charge for the police investigation in this case?
Detective Markowitz.
Thank you, Your Honor. No further questions.
Mr. Powell, anything that needs follow up there from your side of things, sir?
No, Your Honor.
All right, excellent. Thank you. Mr. Littlewood, may we excuse Professor Van Owen from the stand?
Yes, Your Honor.
All right, excellent. Thank you for your testimony, Professor. Any additional witnesses at this time that the defense would like to call?
No, Your Honor. The defense rests.
All right, folks, I think that means we're ready for closing arguments. I'm all set to launch into that if everyone else is. Let's start with the people if we're set.
Your Honor, I would just like to confirm that any remaining time in my closing argument would be reserved for rebuttal.
My recollection is Ms. Sayers had taken care of that as a housekeeping matter. I've got that on my notes here, sir. So yes, you've preserved that just fine. You're all set to go.
Thank you. Your Honor, counsel, members of the jury. Towers, texts, and tantrums. On Friday, March 6, 2020, Mackenzie Brackman got an alert on his phone. Motion at your front door. Seconds later, he got another. Motion at your side gate. He rushed to the kitchen to grab a defensive weapon, but before he could get to the back door, the intruder had entered his home. He struggled with the intruder. He fought for his life, but he was stabbed in the back. And the bright light of Mackenzie Brackman extinguished as he bled out on his entryway floor. Little did he know, his attacker was Avery Becker. Members of the jury, my name is Chalmers Powell, and along with Feliciana Sayers and Madeline Proctor, we represent the people of the state of Colorado. In today's case, we carry the burden of proof. That means we had to prove beyond a reasonable doubt that the defendant committed second-degree burglary and, by extension, first-degree murder. As the judge instructed you, a reasonable doubt isn't a vague, speculative, imaginary doubt, but a doubt that would cause you, a reasonable person, to hesitate to act in matters of importance to yourself. We have to prove to you that the defendant entered Mr. Brackman's home with the intent to commit criminal mischief. That is second-degree burglary. And we also had to prove to you that Mr. Brackman died while the defendant committed that crime. That is first-degree murder. We have met our burden. Let's walk through how. At the beginning of this trial, Ms. Proctor asked you to focus on three things: towers, texts, and tantrums. Towers. The towers prove that the defendant was at Mr. Brackman's home. Her phone pinged not once, not twice, but 3 times right there. He wants you to believe that she just happened to lose her phone the day before the murder. But Taylor Perkins and Miss Becker can't even get their story together. Miss Becker said it wasn't until the morning of March 6th that she realized her phone was missing. But Taylor Perkins said they realized together when the two got together. Either way, the claim that Avery Becker didn't realize her phone was missing until the next day doesn't make sense. It's not reasonable. Texts. The texts prove intent to commit criminal mischief. I'm going to wait until he's at work, break in, and trash it. He admitted to it. He wants you to believe that Blair Rollins and Avery and Alex Fuentes conspired against her to frame her for this. That's not reasonable. That's the speculative doubt. That's the imaginary doubt. They just want you to imagine it. Tantrums. The tantrums prove that the defendant went to Mr. Brackman's home. Avery Becker got mad when she was criticized by Coach Brackman, so she went out and vandalized the car. This created all the motive in the world when she was kicked off the mock trial team. The height of her high school career, but she went out and threw another tantrum. I'm going to get him back if it's the last thing I do. She did. And now, beloved mock trial coach is dead. Now, in a moment, Mr. Littlewood will stand right here and try to sweep all of this evidence under the rug. Don't let him. Towers, texts, and tantrums lead to the truth. Avery Becker is guilty as charged. Thank you.
Thank you, Mr. Powell. Mr. Littlewood, before you jump in, let's get a formal time for Mr. Powell's rebuttal. 49 seconds left there, sir. All right. Excellent. Mr. Littlewood, we are ready for your closing argument. Sir, you may proceed when you are all set to go.
Thank you. Are the timekeepers ready?
Yes, Your Honor.
Members of the jury, the mere fact that we are here in court today is a gross miscarriage of justice by the Denver Police Department. Humans are complex creatures with complex problems. Police investigation in this case is an effort to turn a complex problem into a simple one by simply neglecting to consider all the evidence. From the beginning of the investigation, Markowitz and Kuzak made up their minds about who they thought had committed this crime and followed only the lines of evidence which suited their premature conclusions, despite the fact that these conclusions simply do not make sense in context and carry more than a reasonable doubt. In each and every foundational piece of evidence, the prosecution's case, they've failed to properly establish that evidence. Their argument is towers, texts, and tantrums. Texts. The most important piece of evidence to the prosecution's case, in fact, the only piece of evidence which could potentially tie Avery Becker to this crime, is the series of text messages provided by Alex Cifuentes. As evidence of these text messages, we have only the screenshots provided to the police by Cifuentes. These screenshots do not show the time, nor the date, nor the phone number of the sender, and now based entirely on Cifuentes' word that these messages were received from Avery, the police are trying to convict an innocent person of a crime she did not commit. Searching Cifuentes' phone to verify the validity of these messages was well within the rights and abilities of the police department, but they neglected to carry out this vital step of the investigation. In addition to their failure to properly establish their own evidence, the police have also made far too much of evidence they were able to properly collect while conveniently ignoring evidence which did not suit their theory. Towers. The police tried to use cell tower analysis of Avery Becker's phone to prove that Avery was at the victim's house when the murder occurred. However, cell tower analysis cannot be relied on to show the exact location of a device, and even so, Avery was not in possession of her phone at the time, having lost it the previous night. At the time of the murder, Avery and Taylor were at the mall searching for her lost phone, an alibi the police completely neglected to investigate. The police could have looked at Taylor's cell tower data to substantiate this alibi, but once again, they neglected to do so. However, Professor Blake Van Owen did view the data, and Taylor's cell tower data proves that they were at the mall when the murder took place. Now, in the defense theory of this case, Alex Cifuentes is lying about Avery sending these messages, while in the prosecution theory of this case, Taylor Perkins is lying about Avery being with him at the mall when the murder took place. No evidence exists to prove that Cifuentes received these messages from Avery, but Taylor's cell tower data does prove that she was at the mall when the murder took place. The police elected to ignore this fact because it does not suit their premature and unfounded theory. In failing to consider other theories, the police neglected to investigate any other suspects they encountered, such as Blair Rollins. One way or another, the police were aware that Blair Rollins fled the state following when the murder occurred, and after Brackman had lost a case wherein Blair's father was sentenced to life in prison. Even with such a compelling suspect, the police elected not to investigate because it did not suit their premature and unfounded theory. It is clear that they had already made up their minds and were not open to any theories but the one they had already formulated. Tantrums. Avery Becker, in all reality, is just a kid. And yes, when she got kicked off the mock trial team, she was angry. But it is completely absurd that a simple and harmless disagreement over something as mundane as mock trial is being presented as a motive for murder. The burden of proof today is on the prosecution. They must prove beyond a reasonable doubt that Avery Becker has committed these crimes. You may find reasonable doubt in their inability to establish the validity of the text messages, in their firm resolve to ignore any evidence which did not suit their theory, in the absurdity of a mock trial dispute being presented as a motive for murder, or in the glaring fact that at the time of the murder, Avery Becker was with their friend Taylor Perkins at the mall. And as everyone knows, you cannot be in two places at once. This investigation is a gross miscarriage of justice, a window into the incompetencies of the Denver Police Department, and an effort to explain a complex problem with a simple solution that simply doesn't fit. Nothing about the prosecution's theory of this case makes sense. Return a verdict, not guilty. Thank you.
Thank you, Mr. Littlewood. Mr. Powell, you have 49 seconds remaining for rebuttal. Oh, Mr. Powell, we're going to pause you there, sir, because you are on mute. So let's get your audio coming through, and then we will restart your 49 seconds. If we can get the timekeepers to let us know in the chat, or just jump in and let us know that you're ready to restart the 49 for Mr. Powell. All right, sir, you can proceed.
Mr. Littlewood just got up here and tried to sell you the idea that this was a complex crime, but you know better. Kyle Kuzak told you that this wasn't a complex crime. It was relatively simple, and it had a relatively simple answer. All the evidence points to Avery Becker. Mock trial wasn't mundane to Avery Becker, and wasn't harmless dispute. She vandalized the car. All the motive in the world to go vandalize the house. Deliver a verdict of guilty. Thank you.
Excellent. Thank you, everybody. We appreciate it. What we're going to do now is I'm going to have everybody turn their cameras off and give the scoring panelists an opportunity to get their ballots submitted. My understanding then is we will be notified when all the ballots are in. We'll do some very brief comments, and then we'll let you folks get some rest before the determinations come out for the next round. So hang tight with us, and we'll get the all clear here in just a moment.
We are just waiting on one more score sheet, and then we'll be able to get started on the feedback.
Thank you very much.
All right, so we are good to start the feedback now. We have all the score sheets.
Excellent. Thank you very much. What I'm going to do is I'm just going to go through the judges in alphabetical order. So what we'll do is we'll give you guys a brief introduction of who we are, some very brief comments, and then we will let everybody out of here because I know you guys either need some rest or have some shoveling to go do. So in any event, Ms. Busby, let's start with you if we could, please.
Hi guys, good morning. My name is Ariana Busby. I am a civil litigation attorney at Hall & Evans. It's a real pleasure to listen to all of you guys this morning. Both sides did a really fantastic job. I don't have any really substantive feedback other than your witnesses. Really, really fantastic, particularly on the prosecution side. I thought that the detective on the prosecution was by far the most compelling detective that I've seen out of all of the mock trial tournaments that I've judged so far, and I've done regionals. I've been judging pretty much nothing but mock trial for the last several weekends, so I was very, very impressed with that. Opening statements on both teams and closing statements, really great use of themes and tying it back together. When you guys started on your closing statements, you immediately reminded me of what was said in those opening statements, and that's exactly how that should operate. So great work there, just calling me back to what this case is about, and really laying out what I should recall from that testimony, and what all the important facts that you want to make sure I didn't forget. So really great job. Really good work, everyone working together. I understand how difficult this is with you guys aren't actually in a courtroom right now, which is so weird. I know this time last year we were all, sitting in a courtroom in Denver. So great work making the most of these really weird circumstances, making the most of what you've got in terms of technology, etc. You guys all did really fantastic. I certainly wouldn't have had the guts to do this when I was in high school. I feel like I barely have the guts to do it now. So just really great use of your time, of your objections, of your questions. Just really great work all around.
All right. My name is Stephen, and thank you, Ariana. Appreciate it. My name is Stephen O'Connor. I'm your presiding judge. I'm a 2015 CU law grad, presently own a general practice litigation firm here in Frisco, which I would advise nobody to try and get to today. I was absolutely delighted with everything that I was able to see here. As some of you may have heard when we got started, Deanna actually, Judge Stamm had asked me to join in on this or suggested to me that this was an opportunity that was available this weekend. I did a lot of debate in high school, but we didn't have mock trial at my high school when I was there many, many moons ago. And so I will tell you, we're actually in the process of hiring an associate at this firm. And if any of you had your licenses, I'd be happy to have you. You are leaps and bounds, honestly, ahead of even most litigators who do this for a living, especially in this forum, in this context, with this being on Zoom. What you're looking at here is my reality on a daily basis. This is where I litigate from on a daily basis. And so being able to see people adapt to a completely new way of doing business in a literal sense is absolutely phenomenal. I thought you guys did a great job with technology, with screen sharing, with incorporating exhibits. That's something that I've seen most experienced litigators really have trouble with as they've been doing this. And I just judged last weekend for the first time a college mock trial tournament. And I enjoyed this a lot better, to be honest with you. I mean, the procedures are more fun. There's a little more action here than there was at the college level, at least in terms of the tournament I was watching. So I was really glad to be able to spend the time with you guys today. And I do appreciate you allowing me to be a part of this for you. One thing that I will say, honestly, like I said, everything was really well buttoned up. I always love to see flips and cross. And so getting to see the other team's theme getting used in close is always a really fun thing for me to see, because you're sitting there and you're going, what wait a minute, I just heard that from the other guy, but now it's not that side of events and I can apply it this way. It really, it's a fun intellectual exercise to watch your jurors go through, but just as an attorney, there's nothing better than taking something that somebody else has spent an eternity polishing up and then making it your own. It's insidious. It drives the other side nuts, and it's really good for jury practice. So, and I will say, as far as all the witnesses were concerned, I believed that everybody was the role that they were fulfilling. I've seen that officer's testimony before, whether I liked it or not, and it was very compelling in terms of what that looked like. So, again, just a massive amount of work I know you guys put into it, and it was shown here. So I really appreciate you guys putting the time into giving us all something that was both entertaining to watch and illuminating in terms of how the practice can be done. Judge Phipps.
Okay. Yeah, I thought you guys all did a great job. My name is Jill Phipps. I have been a family law attorney in Fort Collins for about 30 years. I coached mock trial at Fort Collins High School for 21 years. So I have sat through literally hundreds of rounds of mock trial. So you guys were all really good. I always harped my kids on themes. I thought themes are really important. I thought both your themes were really good. I especially like towers, texts, and tantrums. And I like the way that you all brought them back up in your closing. I also like the way that both of your closing attorneys used the other team's theme. That's really good when you can turn around and turn their theme on them. So you both did that. So I was really impressed by that. I thought all the witnesses did a really good job. Miss Bruner, I loved your portrayal. You were really fun to watch. And on the other side, Mr. Gravdahl, you were very believable. I loved your portrayal of the expert. And then all the attorneys, I thought you did a really great job too. Miss Proctor, you had a great demeanor for an attorney. I thought you were great. You'd be great in a courtroom. And Mr. McKinney also, I thought you had a really good demeanor. So all of you did a great job. I'm sure you're all tired. So that's enough comments for today, but I enjoyed being here with you.
Judge Stamm. And Deanna, I don't know if we have you over there.
Hello? Okay.
We got you.
Okay, thank you very much. To everyone, I apologize. I'm not going to turn on my camera at this time. I had power earlier, but right now we're running on a generator. So you get my voice and that's about it. I want to say thank you to everybody for taking the time to come here, for having the mental fortitude to stick with this program, because this is very difficult. The time commitment to this is absolutely intense. And thank you, all of you from each team, for having the mental fortitude to stick with it. This is absolutely fantastic. And thank all of your families and friends for allowing you to give up this so-called personal time in order to participate here. I concur with everything that has been said. I really appreciate the absolute cohesion that each team has shown. You have demonstrated that all of you attorneys have worked incredibly well with each of your witnesses, and for opposing counsel on each cross, very nicely done. That being said, I am going to call out the witnesses. You guys make or break your teams. And today, for this round, this has been absolutely phenomenal. Each of you did an excellent, exemplary job of showcasing exactly how witnesses should behave, especially on cross. It was absolutely wonderful to see some of your witnesses' attitudes coming out, especially when you were trying to test your crossing attorney. So very incredibly done there. good job to everyone. With that, I am going to bow out, but thank you all again for being here and best of luck.
Thank you guys so much. We really, again, we do appreciate it. Please stay safe, stay warm, and just on behalf of the legal profession, please stick with this. You guys, we would be honored to have you as members of the bar. All of you were phenomenal. So thank you so much. Go in peace and be well. We appreciate it.
Thank you, Your Honor. Thank you.
Good job, everyone. Thank you,
Yes,
Your
and
Honor.
thank you to all of our volunteers for helping. I know it's a big time commitment, but we really appreciate